Ms. Sweeney, are we good to go ahead and swear in and start the trial? So at this time, for housekeeping purposes, the way that we're going to handle the video is that I'll have you turn on your video to be sworn in, but once you've been sworn in, everyone should turn off their video unless they are actively speaking or if they're the opposing counsel for that witness. Timekeepers, I would also ask that you keep your video off unless you need to actively provide a time, or you can also use the chat in addition as well to alert your team members of time. So at this time, if all the team members could please turn on their video and microphones so that I can swear you in. All right, please raise your right hand. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
I do.
I do.
All right, thank you. And if witnesses, you would please turn on your video and microphones. And please raise your right hand. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
I do.
Thank you. And scoring panelists, if you would turn on your video just for this moment, and please raise your right hand. Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Do.
All right, thank you. You may turn your videos off at this time. All right, it appearing that both sides are ready to proceed with trial, I just want to address a few housekeeping matters and then see if either party has any preliminary matters to be brought before the court. Having just sworn in the witnesses, they are all presumed to be sworn. Per the rules of this year's mock trial competition, attorneys do not need to stand when addressing the court or during examinations, but they may stand if they choose to do so. And with respect to exhibits may either be screen shared via Zoom, or attorneys and witnesses may refer to exhibits as being in the file, and it's presumed that the jury members have a copy of the exhibits in front of them. So it's each attorney's choice on how they want to do it. It's also presumed that if the attorneys if the attorneys decide to do it via screen share, that during exhibit foundation, the jury can't see that, and then you may ask for it to be quote unquote published to the jury, and then it will be presumed that that's the point when the jury can see the screen share. Are there any other preliminary matters first from the prosecution?
Yes, Your Honor. We request that immediately after an exhibit is admitted into evidence, it can be published to the jury for expediency's sake without any further request.
We're going to assume that they'll be constructively published, but I would ask you to ask for that to happen.
Yes, Your Honor.
Anything else, Ms. Kidder?
Nothing further, Your Honor.
And any preliminary matters from the defense?
Yes, just a few more, Your Honor. We also seek the court's permission to deem any exhibit that has been shared by means of screen sharing for the purposes of laying foundation to have been constructively handed to opposing counsel for their review.
Yes, that's fine.
And we ask that the court defendant may constructively sit at the counsel table for purposes of conferring via Zoom chat with counsel, and thus serving as the defense advisory witness.
Yes, that's fine.
And those are all our preliminary matters, Your Honor. Thank you.
All right. Prosecution, are you ready to proceed with opening statements?
Yes, Your Honor.
All right, you may proceed.
Your Honor. Motive, mischief, murder. The case today is about someone named Avery Becker, who had a motive to retaliate against the victim, Mackenzie Brackman. The act of retaliation, to vandalize the victim's home, a crime known as criminal mischief. In the process of that mischief, the victim surprised the defendant, they struggled, and the victim Mackenzie Brackman was murdered. Good afternoon, members of the jury. My name is Clara Ann Wind, and I and my co-counsel represent the people of the state of Colorado. In this trial, we are seeking justice for Mackenzie Brackman. Avery Becker had a vendetta against Mr. Brackman. They hated each other. Mr. Brackman was the coach of a mock trial team, and the defendant was the insolent team member. This relationship deteriorated so fast and so dramatically that it created a recipe for murder. This is what the evidence will show. Mackenzie Brackman was a lawyer who volunteered to help coach the Colorado high school mock trial team. The defendant was on that team, and to the defendant, that team was his entire identity. He thrived on, without preparation, dazzling the jury with his theatrical performance. The coach, on the other hand, demanded preparation and practice. These two headstrong competitors clashed continuously, with Mr. Brackman believing the defendant was arrogant and lazy, and the defendant believing Mr. Brackman was a terrible coach and lawyer. How can we know the defendant was capable of committing such a crime, members of the jury? We know this because this was not the first time something like this had happened. Just weeks earlier, the two had a series of arguments, each one building on another. It came to a head and they blew up at one another. The defendant's reaction was disproportionate. The defendant caused extensive damage to Mr. Brackman's expensive Porsche car. Mr. Brackman caught him in the act of vandalism and, in anger on the spot, kicked him off the mock trial team. The defendant was determined to retaliate. How do we know this, members of the jury? We know it from the defendant's own words. First, the defendant told his mother, "I will get back at Mr. Brackman if it's the last thing I do." Second, the defendant texted a friend and said that Mr. Brackman was going to be really angry when he sees what I do to his house. I'm going to wait till he's at work, then I'm going to break in and trash it. Members of the jury, the defendant did just that. This motive of retaliation compelled him to commit criminal mischief by breaking into the Brackman home. Only something went terribly wrong. Mr. Brackman surprised the defendant, they struggled, and Mr. Brackman was murdered. It's not what the defendant set out to do, but under the law of this state, what the defendant did constitutes first-degree murder. Today, we will call 3 witnesses. First, Cal Cusack, a crime scene reconstructionist and investigator, to testify about the crime scene and how it supports the theory that this was criminal mischief gone wrong. Next, we will call Alex Fuentes, a former classmate and friend of the defendant, to testify about the text that she received about breaking into the Brackman home. And finally, we will call Jordan Markowitz, the lead detective on this case, to testify about the evidence and how the cell towers placed the defendant's phone near the scene of the crime at the time of the murder. The defense will also call 3 witnesses who will not be credible. They may try to blame this crime on some phantom named Blair Rowlands, someone they have no evidence for and who is not even here to testify today. We know they're going to call Taylor Perkins, the best friend of the defendant, who claims to have been with the defendant during the time of the murder, except there is no evidence to support this friend's story. They will also call a crime scene investigator, who is a hired gun for criminal defendants. This investigator is incredibly biased against the prosecution and did no real investigating. Finally, the defendant will take the stand. He will have to admit that he hated Mr. Brackman, that he vandalized his car, and that he promised to get back at Mr. Brackman. As the prosecution today, we have the burden of proving beyond a reasonable doubt that Avery Becker committed the crimes of second-degree burglary and first-degree murder, because that is exactly what the evidence will show, members of the jury. We ask that you find Avery Becker guilty. Thank you.
And defense, you may now present your opening statement.
May I proceed, Your Honor?
You may.
Reckless, rushed, guilty until proven innocent. Members of the jury, do those sound like the descriptors of an honest, well looked into police investigation? Today, we are going to show you the reality of Detective Markowitz's investigation and the falsity of the prosecution's story. Today, we are going to tell you about Avery Becker. Avery graduated from Colorado High School in June 2020. But instead of celebrating and moving on to the next stage of his life, the police chose Avery as their suspect for a felony murder and second-degree burglary. Today, members of the jury, it is your job to listen to the facts of the case. The burden of proof lies on the prosecution. They must prove to you beyond a reasonable doubt that Avery Becker is guilty of these crimes. And per jury instruction number 2, if you cannot find evidence of Avery's guilt beyond a reasonable doubt, you must find him not guilty. Now, members of the jury, you will hear from the prosecution today about their investigation and about their conclusions. We will show you that those fragile conclusions came only from faulty evidence, mistakes, and a rush to condemn a suspect. You will hear that the police relied heavily on the testimony from one mock trial team member, where they received their first and only suspect, Avery Becker. They never looked into other suspects who had significant reasons to be angry with the victim. They relied on video clips that show only a person in a mask entering and leaving the victim's house. And they relied on potentially faulty text messages and cell site data. But let's start at the beginning. You will hear from 3 witnesses today: Avery Becker himself, Taylor Perkins, Avery's best friend who was with Avery on the day of Coach Brackman's murder. And finally, you will hear from private investigator and Professor Blake Van Owen. Avery will tell you that, yes, he and Brackman did have arguments with each other, but he would never commit murder over petty squabbles. You will see Avery as a talented student, a good friend, and a lover of mock trial. But he was also a high schooler, and high schoolers make mistakes, like angrily drawing on a car with what turns out to be permanent marker. Members of the jury, you will see that Avery could not have been pushed so far as to commit murder. Furthermore, you'll hear from both Avery and his best friend, Taylor Perkins, that on the day of the murder, they were looking for Avery's lost cell phone, scouring the places they had been the night before. You'll see that neither of them could have been at the scene of the crime. Finally, you will hear from Professor and private investigator Blake Van Owen that the police came to the easy conclusion regarding the murder of Mackenzie Brackman. She will show you the assumptions made by crime scene reconstructionist Kyle Cusack and the mistakes made by Detective Markowitz. She will explain to you that yes, there is physical on-scene evidence that an intruder broke into the home of the victim, but that the police fit this evidence to Avery instead of letting it lead to their victim. In regards to the location of Avery Becker's cell phone, Van Owen will share that cell tower data cannot definitively locate a phone, and that Detective Markowitz never looked at any cell site data other than Avery's. Again, members of the jury, the prosecution has the burden of proof today. They must prove to you beyond a reasonable doubt that Avery Becker was at Mackenzie Brackman's house on March 6, 2020, that he committed criminal mischief, committed second-degree burglary, and in doing so, murdered Mackenzie Brackman. And so, members of the jury, as you listen to Avery and Taylor tell you the story of March 6th, as you listen to Professor Van Owen explain all of the discrepancies of the investigation, you must ask yourself, is Avery innocent until proven guilty? Or has this investigation made him guilty until proven innocent? Thank you.
Thank you. The prosecution may call its first witness.
The people of the state of Colorado call Kyle Cusack. May I proceed, Your Honor?
You may.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Kyle Cusack. That's K-U-Z-A-K.
Ms. Cusack, what is your profession?
I am a Colorado Bureau of Investigation certified crime scene reconstruction investigator, but that's a mouthful, so we just use the term CSR.
As a CSR, will you tell the jury what you do?
Absolutely. I investigate complex crime scenes, including home invasions, burglaries, and other property crimes, homicides, domestic violence, fatal accidents, and armed robberies.
How many years of experience do you have as a CSR?
I have 19 years of experience working as a CSR.
What have you been doing in your most recent years?
For the last 3 years, I have worked for the Denver Police Department.
In the case today, the defendant is being charged with second-degree burglary and first-degree murder. Do you have any experience investigating those types of crimes?
Yes, that's exactly what I do for a living.
Were you involved with this case?
Yes, I was the CSR assigned to the murder of Mackenzie Brackman.
Your Honor, the people of the state of Colorado offer Kyle Cusack as an expert witness in crime scene reconstruction and investigation.
Ms. Kenny, any voir dire or objection?
No voir dire or objection, Your Honor.
All right. The witness will be tendered. I'm sorry, would you say the fields again?
Crime scene reconstruction and investigation, Your Honor.
Ms. Cusack will be tendered as an expert witness in crime scene reconstruction and investigation.
Ms. Cusack, how did you become involved in this case?
I was called to investigate the death of Mackenzie Brackman on March 6, 2020 at 444 South Flower Street.
Tell the jury what you did to investigate the case.
Well, I've actually developed my own 5-step process for crime scene reconstruction and investigation, and I applied it here. So first, I created evidence tracking sheets.
Please turn to Exhibit 17, which I believe my co-counsel will pull up in front of you. What is that?
Oh, those are my evidence tracking sheets.
And how do you know?
Well, I personally created Exhibit 17.
Is Exhibit 17 a fair and accurate copy of the document that you created?
It most definitely is.
Your Honor, the people of the state of Colorado offer Exhibit 17 into evidence.
Any objection from the defense?
Your Honor, before I make any objection, I'd just like to clarify, is counsel offering all of Exhibit 17, including both the witness tracking sheet, evidence tracking sheet, and flow chart, or just one of the tracking sheets?
Ms. Williams?
Yes, Your Honor. We are offering the entire exhibit, though we will only be using this first page.
Yes. Well, then in that case, I would object on the grounds of hearsay, and also I'll leave that objection out if you will be only using the first page. If that's all you'll be using, just hearsay will be only objection.
All right. Ms. Wynn, to your response?
Yes, Your Honor. This is a recorded recollection under exception 803. Let's see. 803.5. Yes. So that is an exception to the rule of hearsay. This is a document that Ms. Cusack has created in the course of her regular activities, and therefore it is an exception to hearsay.
And Ms. Kenny, why is this not a business record?
Well, Your Honor, I was wondering if counsel meant 803.6, records of a regularly conducted activity, and not a recorded recollection.
Yes, my apology.
Well, Your Honor, I believe that these records that Ms. Cusack creates aren't standard for every single investigation. They shift and change. They're not something that you input just regularly without even thinking. And to me, a regularly conducted activity is something that someone does, just standard procedure.
Well, it's a close call, but I will allow it. However, I will only admit page 1 of Exhibit 17, so that will be admitted over defense objection.
Yes, Your Honor.
Your Honor, may my co-counsel publish this to the jury?
Yes, Your Honor. Yes.
Ms. Cusack, the defense alleged in their opening statement that the police limited their investigation to Avery Becker. Is that true?
No, as Exhibit 17 shows, the police looked at 3 suspects. The primary suspect was Avery Becker. The secondary suspect was Alex Cifuentes, and the tertiary suspect was Blair Rollins.
Do you have understanding of why the police ultimately focused on Avery Becker?
Well, there was absolutely no evidence whatsoever that anyone else was involved in this crime.
What did you do after you created your evidence tracking sheets?
I went to the crime scene after it was processed by the crime lab. I collected the police reports, all the photographs, several videos from 3 different ring security devices at the scene, and a copy of the official autopsy report.
What did you find at the crime scene?
I saw the ring doorbells and their video footage. I found scuff marks near the back door. There was an open drawer with several knives in it, and a knife block on the counter with an empty slot in it, perfect for a chef's knife. There was also a broken plate on the floor near the table, and blood droplets leading to the front door, as well as a large pool of blood and a bloody chef's knife.
What did you do next?
I watched the videos from the Ring security devices.
Please turn to exhibits 10 through 13. What are they?
Those are the Ring security videos showing the footage from the day of the murder.
And how do you know?
Well, I was at the scene and I saw the devices. The videos come from those devices, and I received these videos from Detective Markowitz.
Are exhibits 10 through 13 fair and accurate copies of the videos you received from the Brackman home?
Yes, they are.
Your Honor, the people of the state of Colorado offer exhibits 10 through 13 into evidence.
Any objection from the defense?
No objection to the videos themselves, but I would ask that before counsel admits these exhibits, she screen shares and shows the exhibits in their entirety for each one. So that jury and everyone involved can see that these exhibits are in fact fair and accurate representations.
Well, I will leave that to counsel to determine, but I think sufficient foundation has been laid for their admission, and since there's no objection, they will be admitted.
Yes, Your Honor. And do we have permission to publish these to the jury?
You do?
All right, Ms. Cusack, for time's sake, let's just go through one of these videos for the jury, exhibit 11, if you would.
Yes, this is exhibit 11. It shows someone matching the height and build of the defendant in a Halloween mask, gloves, and baggy clothing entering the residence through the back gate.
Let's take a step back and talk about the victim for a minute. How did Mr. Brackman die?
He was stabbed near his shoulder blade. Specifically, a knife penetrated his aorta, and when it was removed, he bled out and died.
What did you do after you visited the crime scene?
Well, I reviewed all the information and evidence I had collected and what I viewed in the house. I analyzed it and I reconstructed the crime scene.
And what did your reconstruction show?
The evidence clearly pointed to a home intruder, most likely a burglar, who entered the residence at a time on a weekday when Mr. Brackman would not have normally been home. Remember, this was pre-COVID when people would actually go to an office for work. However, Mr. Brackman was home that day, and he grabbed a knife from the knife block, struggled with the intruder, and was killed.
You just testified that Mr. Brackman had a knife. What about the intruder? Did they have a knife with them when they entered?
Although it is possible, the videos show no evidence that the suspect had a knife on them, and it would have been extremely difficult to carry that large of a knife and those baggy clothing. Because of this, I believe that the knife came from Mr. Brackman's knife block.
Why do you believe that?
Well, when I analyzed the crime scene, there was only one empty slot in the knife block, and it happened to be of the right shape and size to store the chef's knife that was used to commit the murder.
Was the chef's knife of the same brand as the rest of the knife block?
No, the knives in the block were from a more expensive set, but we found no such knife that went into that slot. So it's likely that Mr. Brackman simply replaced the damaged knife.
Ms. Cusack, did you come to any conclusion about whether Avery Becker committed this crime?
No, I reconstruct and investigate crime scenes so that detectives can use that information to help them decide who committed the crime.
And in your reconstruction, did you come to any conclusions?
Yes, I most certainly did.
In your expert opinion, what happened at 444 South Flower Street on the day of the murder?
This was clearly a planned break-in gone bad.
Please explain.
The intruder had knowledge of the victim's property and chose a time of day when the victim's patterns would have placed him outside the home. Now, Mr. Brackman was alerted to the intruder's presence either by the Ring doorbells or by seeing the intruder directly. Either way, Mr. Brackman grabbed a knife from the knife block, struggled with the intruder, and was killed. All of this evidence led me to the conclusion that the intruder did not originally intend to kill Mr. Brackman, but Mr. Brackman's surprise presence in his home, his awareness of the intruder, and his attempt to defend himself altered those circumstances.
Thank you. I have no further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Cusack.
Good afternoon.
I'd like to ask you a few questions about your reconstruction of the crime scene. It involves a fight between Mr. Brackman and the intruder. Is that correct?
Oh, it wasn't a fight. It was a struggle.
A struggle between Mr. Brackman and the intruder.
Yes, ma'am.
And one of your supporting pieces of evidence for this struggle was scuff marks on the floor, yes?
Yes.
And you reviewed those scuff marks when you went to the house to reconstruct the scene.
I'm not exactly sure what you mean by that. I observed the scuff marks on the floor, if that's what you're asking.
Yes, you observed the scuff marks on the floor.
Yes, I did.
And would you recognize a copy of these scuff marks if it was shown to you?
Oh, absolutely.
Your Honor, may I have permission to show the witness what has been previously marked as defense's Exhibit 18?
You may.
My timekeeper will pull that up. Now, Ms. Kuzak, do you recognize this picture of the scuff marks?
Yes, ma'am, I do.
Would you say this is a fair and accurate depiction of those scuff marks?
Yes, it is.
Your Honor, I move to admit Exhibit 18 into evidence.
Any objection from the prosecution?
No objection, Your Honor.
All right, Exhibit 18 will be admitted.
Thank you, Your Honor. And may I have permission to publish Exhibit 18 to the jury?
You may.
Now, Ms. Kuzak, scuff marks cannot be carbon dated, can they? I can rephrase, Ms. Kuzak. You don't know how old these scuff marks are.
No, I do not.
And these scuff marks, they're by the door, are they not?
Yes, they are.
And they take the shape of parallel lines, is that right? About?
Yes, I guess you could say that.
And to the best of your knowledge, not as an expert, just as a lay witness, people normally walk with their feet in parallel lines. Would you agree?
I think it would depend on where they were going and what they were doing.
You would say that sometimes people don't walk with their feet in parallel lines?
Well, it would depend on the person.
Okay, thank you, Ms. Kuzak. And normally when you have a piece of furniture like a chair, those legs go down in parallel lines. Is that right?
Yes, that's how that would work yes, that's how that would work.
Thank you, Ms. Kuzak. Timekeeper, I'm done with Exhibit 18. Now, you also discussed ring videos that you reviewed for this case.
Oh, yes, I did.
Now, Your Honor, I believe that Exhibits 10 and 11 were both already admitted, but I'd like confirmation. I know they showed 11, but that 10 was also already admitted. If
Yes,
not, I will.
Both have already been admitted and you may publish them.
All right, thank you, Your Honor. I would ask permission to pull up previously admitted Exhibits 10 and 11.
Permission granted.
Now, Timekeeper, if you could move to Exhibit 11 first. Thank you. Now, Ms. Kuzak, you've referred to just one intruder as you've been giving your explanations. Is that correct?
Yes.
Now, Timekeeper, if you could come and zoom in on the shoes for this exhibit, please. As close as possible. Now, Ms. Kuzak, I think you'd agree that you can see, if you look closely, 5 little silver circlets on either side of this shoe, on either side of both of these shoes.
Yes, you can.
And you can see laces on these shoes as well.
Yes, you can.
Now, Timekeeper, would you please move to Exhibit 10? And zoom in on the shoes when the time arises. Now, I think you'd agree, looking closely, that you can't see any of those little silver circlets on these shoes.
You cannot.
And you cannot see laces on these shoes.
Objection, Your Honor. Outside the case problem.
Your Honor, as these videos are included in the case problem and 2 different sets of shoes are seen in these videos, these 2 different sets of shoes are included in the case problem. This is a part of the evidence. We have found something within the case problem that we are wishing to ask Ms. Kuzak about.
Response, Your Honor.
Briefly.
Yes, Your Honor. It is not my witness's fault for anything that the people who wrote this problem got wrong in these videos. This does not reflect on Ms. Kuzak's credibility or the accuracy of her investigation, that this is a minor detail that they missed.
Your Honor, I believe we can't say what the people who created these videos were thinking. Anything that is within the case is part of the case problem and part of evidence and can be used as such.
The objection will be overruled. Ms. Kinney, you may inquire as to this witness about exhibits that were admitted through this witness, but just be mindful of the witness's ability to stay within her own statement. But you may proceed.
Of course, yes, Your Honor. Now, Ms. Kuzak, nowhere in your statement or your report do you mention a discrepancy within these shoes.
No, I do not.
Thank you, Ms. Kuzak. Your Honor, or not Your Honor, Timekeeper, I am done with exhibits 10 and 11. Now, Ms. Kuzak, you also mentioned a witness tracking sheet. Is that right?
Yes, Exhibit 17. I created that.
Now, Your Honor, may I have permission to pull up what has been previously admitted as Exhibit 17?
Yes.
Now, Ms. Kuzak, nowhere on this tracking sheet does it say who was conducting those interviews. Is that correct?
Oh, I collected the police reports, and that's how I created this.
Yes, my question was, Ms. Kuzak, nowhere does it say who was conducting those interviews.
No, it does not.
And Ms. Kuzak, the dates underneath the interview report in that column for reference, those dates are all in June. Is that correct?
Yes, ma'am.
And Avery Becker was convicted of this crime in March. Is that right?
I do not know when Avery Becker was convicted of this crime. I didn't convict Avery Becker of anything. My job is to reconstruct crime scenes so that detectives can use that information, not to convict anyone.
Yes, Ms. Kuzak. Yes, of course. And Ms. Kuzak, you read over the witness statements in preparation for today's trial. Is that correct?
I reviewed Professor Blake Van Owen's witness statement.
Professor Blake Van Owen's witness statement. Well, then, Ms. Kuzak, let me just ask you, on both Mr. Perkins and Mr. Becker's summary of information of evidence, it says provided statement. Is that correct?
Yes, it does.
But on Ms. Cifuentes and Mr. Digby's summary of information, there is no provided statement on there. Is that correct?
I am not seeing that.
And none of these interviews or records of these interviews are included in the materials for this case.
Objection, Your Honor, beyond the scope of this witness's expertise. This witness is a crime scene investigator. She does not investigate suspects.
Your Honor, I can move past that question.
All right.
Now, Ms. Kuzak, oh, thank you, timekeeper. I am done with Exhibit 17. Ms. Kuzak, you said yourself that you wished you had more evidence for this case. Is that right?
Oh, that's always true. I would love to have more evidence at any crime scene.
So it's fair to say you made a number of assumptions, yes?
I didn't make assumptions. I came to conclusions based on the facts.
Of course, you don't make assumptions.
Within I could make assumptions within a reasonable degree. Yes, I could do that.
And you had no DNA data for this case other than that of Mr. Brackman?
I did not have any DNA other than that of Mr. Brackman's.
You had no fingerprint data for this case other than that of Mr. Brackman?
Well, yes, the intruder had gloves on, so it would have been extremely difficult to do that.
Of course. You have no video from inside the house as the crime was taking place?
No, I do not.
And you had no eyewitness testimony for this crime?
Well, the only witness from this crime is dead.
Yes. Thank you, Ms. Kuzak. Thank you, Your Honor. No further questions.
Any redirect examination, Ms. Wind?
Yes, Your Honor. Before I begin, may I ask for a quick time check?
Really?
Yes, you have 17 minutes, 37 seconds.
Thank you. Ms. Cusack, when you are doing your investigations, why is it that you can come to your conclusions?
Well, I look at all the evidence, I analyze it, and I reconstruct the crime scene, and that helps me come to my conclusions. I base it on solid facts.
So do you need to have video evidence to know what happened?
No, you do not.
Thank you. I have no further questions, Your Honor.
All right. This witness may step down and prosecution may call their next witness.
The people of the state of Colorado call Alex Cifuentes. May we proceed, Your Honor?
You may.
Good afternoon. Please introduce yourself to the jury.
My name is Alex Cifuentes, and I know that's kind of an unusual last name, so I'll spell it for you. It's Sifuentes.
Mr. Cifuentes, do you know the defendant?
Yeah, Avery and I've been best friends for years.
Your Honor, the people request that the defendant briefly turns on her screen, or his screen, my apologies, for the purposes of an identification.
Yes. Mr. Becker, if you would please turn on your video.
Mr. Cifuentes, do you see the defendant on your screen?
Yes, I do.
And what is he wearing?
It appears a black suit jacket and white shirt.
Your Honor, let the record reflect Mr. Cifuentes has identified the defendant as Mr. Becker, and Mr. Becker's screen can be turned off at this time.
The record will still reflect. Thank you, Mr. Becker. You may proceed, Mr. Holtzinger.
Mr. Cifuentes, where did you spend the most time with the defendant?
We were both on the Colorado High School mock trial team.
Why did you join the team?
It was actually Avery who talked me into it, and it sounded super cool.
As you know, the defendant is on trial for the murder of Mackenzie Brackman. Did you ever have any opportunity to see the defendant, Mr. Brackman, interacting with each other?
All the time.
In what context did you see them interacting?
At our mock trial practices and competitions.
How would you describe their relationship based on your observations?
It was terrible. They were always really frustrated with each other, and it kind of seemed like they hated each other.
Did you ever see any actual conflict between the two of them?
Yes. One day, when Avery was late for practice, again, Mr. Brackman got big mad.
Could you tell the jury what happened after Mr. Brackman got so mad?
He demoted Avery to the B team.
What happened after the defendant got demoted?
Taylor Perkins, who was good friends with Avery, quit the team. That forced Mr. Brackman to put Avery back on the A team.
How did the team do after that?
At regionals, we advanced to state. Avery won Best Attorney and Best Closing Argument awards.
Did those awards make things better between the defendant and Mr. Brackman?
No way. Just the opposite. At the next practice, Mr. Brackman was super critical of Avery for not preparing, despite those awards.
Could you tell the jury if Mr. Brackman's comments had any impact on the defendant that you perceived?
Avery got very angry and left practice.
What happened
Objection,
after
Your Honor, speculation. There is no way that this witness can know the mental state of Avery Becker.
Response, Mr. Holtzinger.
Your Honor, under Rule 602, this is not speculation because Mr. Cifuentes has personal knowledge as to the emotional state based on his observations of the defendant. He will later testify that the defendant stormed out of practice, and based on logical observation alone and not observation of mental state, he could perceive that the defendant was pretty angry based on her actions. So therefore, this is not speculation.
Response, Your Honor.
Briefly.
Yes, but however, this witness said that Avery was angry. There's no way for him to know for sure if Avery was angry. He can assume that Avery was angry, but there's no way that he can know for sure if Avery was angry, and so therefore it is still speculation.
The objection will be sustained in terms of the way the question and answer was phrased. The witness may testify regarding his observations and how Mr. Becker appeared, but cannot opine or testify as to any emotions or mental state of Mr. Becker.
Mr. Cifuentes, did the defendant leave practice after Mr. Brackman talked to them?
Yes, it appeared to me that Avery got very angry and left practice.
What happened after the defendant left practice?
I saw Avery grab a permanent marker on the way out, which seemed kind of weird.
What happened after the defendant grabbed a permanent marker?
Mr. Brackman had a dope car, a 1986 Porsche 911, and Avery wrote Worst Attorney Award in permanent marker on it.
What happened after this act of vandalism?
Mr. Brackman kicked Avery off the team completely.
How did the defendant respond to being kicked off the team?
Avery wanted me to help her get back on the team, and I tried, but there was no way Mr. Brackman was going to let her back on the team after what he did to his car.
After the vandalism incident and Mr. Brackman kicking the defendant off the team, did you communicate with the defendant in any way?
Yes, by texting.
Please turn to what has been marked as Exhibit 14.
Okay.
Do you know what Exhibit 14 is?
Yes, it is a screenshot of the text conversation between me and Avery.
How do you know?
These messages were sent to my phone, and I was the one who captured the screenshots.
Is Exhibit 14 a fair and accurate copy of the screenshots you captured of your conversation with the defendant?
Yes, it is.
How do you know it was the defendant who was texting you and not some random number?
Well, we have texted many times. Her number was saved into my phone, and we were talking about things personal to her that only she would know.
Later, we believe that opposing counsel is going to ask whether these screenshots were doctored or manipulated in any way. Did you do that?
No way. I don't even know how to do that. These were the messages we sent each other.
Your Honor, the people of the state of Colorado offer Exhibit 14 into evidence.
Any objection from the defense?
Yes, Your Honor, I will object on the grounds of hearsay.
Your Honor,
What specifically about it is
this is
hearsay?
an out-of-court statement used to prove the truth of the matter asserted, Your Honor.
Mr. Holsinger? Any response?
Your Honor, Your Honor, the defendant's comments are not hearsay because under Rule 801D2, they are a statement by a party opponent. As for Mr. Cifuentes' comments, they are not being offered for the truth of the matter, but for the effect they had on the listener, in this case, the defendant. Without these, well, we are going to be using this exhibit for the purpose of talking about the defendant's own statements, and Mr. Cifuentes' comments to the defendant were what prompted the defendant to send these statements to him. Without Mr. Cifuentes' comments, these are an incomplete exhibit and are therefore being offered for the effect on the listener and not the truth of the matter and are not hearsay.
All right, the objection will be
Response.
overruled.
Okay, sorry, Your Honor.
Your Honor, may we publish to the jury?
You may.
Mr. Cifuentes, in what color are your words on the screen?
Green.
When the defendant found out that she would not get let back on the team, how did she respond?
Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. And then she said, I'm going to wait until he's at work, then break in and trash it.
Mr. Cifuentes, how did you become aware of Mr. Brackman's murder?
A detective called me about it.
What did the detective want?
The detective wanted to talk with me and also wanted the screenshots of the text conversation between me and Avery.
What did you do after talking to the detective?
I have the screenshots on my phone and I emailed them to the detective.
Did you also talk to anyone who worked for the defendant?
Yeah, Avery had some sort of weird private investigator who tried to talk to me. I did not want to, but she insisted.
How did that go?
It was just awful. She tried to get me to lie. She wanted me to say that I faked the text messages with Avery, which I obviously didn't.
Later, we will hear allegations that someone stole the defendant's phone. Did you steal the defendant's phone?
No way. Why in the world did I do that?
Finally, did the defendant have a reputation among the mock trial team?
Oh, yes.
What was that reputation?
Avery had a reputation to do this crazy thing as a witness where she made things up and convinced the judge and jury that it was completely true.
Thank you, Mr. Cifuentes. No further questions.
Mr. Ebel?
It's Ebel.
Ebel, cross-examination.
Yes, Your Honor. May I begin?
Yes.
Good afternoon, Mr. Cifuentes.
Good afternoon.
So you went to Colorado High School.
Yes, I did.
And you were a member of the mock trial team.
Yep.
The coach of the team was Mackenzie Brackman, correct?
Oh, yeah.
And Avery Becker was also on this team, right?
Yeah, my best friend Avery was on the team too.
Right. And you say you are basically best friends with Avery Becker.
Yeah, we would spend a lot of time with each other at mock trial and school, and we really liked each other.
In fact, you credit Avery for helping convince you to join the mock trial team.
Yeah, when I was a freshman, he's actually the one who convinced me to try it out.
However, in your witness statement, you don't mention hanging out with Avery outside of mock trial in your witness statement, do you?
We mostly just would hang out with each other at mock trial, at the Fry Shack sometimes too, actually.
Yeah, but Avery Becker was basically your best friend.
Yeah, I said that. I've already said that.
Now, moving on, Avery and Brackman had their differences, right?
Yeah, they were always like really frustrated with each other.
And these differences eventually got Avery demoted from A team.
Yeah, I don't remember when it was, but it was sometime she got demoted to the B team.
But Avery rejoined the team in time for the regional tournament.
Yeah, actually, one of her other close friends, Taylor Perkins, quit the A team, which actually forced Mr. Brackman to put Avery back on the A team.
Right. And at that same regional tournament, Avery won Best Attorney and Best Closing awards.
Yeah, she did.
But you felt that this was a slap in the face.
Objection
Yeah, 'cause-
relevance.
Sorry, can you
Your
repeat
Honor.
I objected to relevance.
that? Response, Mr. Ebel?
Your Honor, this is relevant as it shows that the defendant and Alex Cifuentes were not really close friends. And so it goes to the matter of the case in general.
Your Honor, may I respond?
Yes.
I believe that opposing counsel is using this to establish Mr. Cifuentes' character. And under Rule 405, character may only be proven by reputation or opinion. And this fact in hand, whether or not Mr. Cifuentes cared about his standing on the team when the defendant got demoted, is not admissible in proving his character. So I believe that this is irrelevant.
Your Honor, I'm not using this to say anything about Mr. Cifuentes' character. I'm simply asking him questions regarding a team member of his.
I do think it is, does marginally have a tendency to prove a fact at issue in this case. So I will overrule the objection.
Could you repeat the question, please?
Yes, but you felt that this was a slap in the face.
Yeah, Avery didn't really prepare at all for regionals, and I prepared a lot, and so it was kind of a slap in the face when he won them, but without preparing.
All right, moving on now. Avery eventually got kicked off the team for good, right?
Yeah, Avery vandalized Mr. Brackman's car by writing worst attorney award on it, and that got her kicked off the team.
Right. And Avery texted you trying to get back onto the team.
Yeah, she wanted me to go to Mr. Brackman and ask him if he could get back on the team.
And you later had an interview with the police detective regarding these text messages.
Yes, I did. It wasn't just
But-
specifically for the text messages, it was for other things, but that was part of the interview.
But you didn't bring your phone with the text messages on them to the interview.
No, actually, kind of funny story. My phone was on the charger and we were in a rush to get out the door. And so I actually forgot it on the charger.
Did the police ever ask for a follow-up interview regarding the phone?
I don't think so. No.
Right. And you later got a new phone.
Oh yeah, because my old phone had terrible battery.
And you have no idea where your old phone is now.
No, it's probably like destroyed now. I don't know what they would do with those.
Yeah. But you sent screenshots of the text messages to the police.
Yeah, I did.
And the police, they accepted them?
Yeah, they accepted the text messages. Yeah.
All right. Now, in your witness statement, you say that you talked to Avery after Avery asked you to get back onto the team, right?
Objection hearsay.
May I ask on grounds what you say?
Your Honor, this question is asking for Mr. Cifuentes to refer to a statement from his witness statement. And as the witness statement is an out-of-court statement being offered for the truth of the matter, this falls under hearsay, despite the fact that it's in his witness statement.
Your Honor, I can rephrase the question if that pleases.
Yes, I thought the reference was to the text message, but yes, if you could ask the question without specifically referring to the statement at this time, please rephrase.
Yes. Now, Mr. Cifuentes, you mentioned that you went and talked to Avery after Avery got asked to leave the team, correct?
Yeah, I think we talked to each other like at the Fry Shack a little bit.
Yep.
Yeah.
And then you also talked to Coach Brackman about trying to get Avery back onto the team, right?
Yeah.
Objection
like I said,
hearsay.
Overruled it. He didn't ask for what was said. He just asked if you talked to him.
Now, you later mentioned that you sent a text message and say that you texted Avery but Brackman wouldn't budge.
I'm kind of
Sorry,
confused.
this would be a lot easier. May I, Your Honor, permission for my timekeeper to pull up Exhibit 14,
Yes,
previously
That's
admitted Exhibit 14.
yes, that's been admitted.
Okay. Now, Mr. Cifuentes, you mentioned that you sent a text message and say that you texted Avery that you talked to Brackman and he wouldn't budge.
Yeah, I told her I would go talk to him.
Now, Mr. Cifuentes, nowhere on Exhibit 14 do you text Avery that you talked to Brackman, do you?
Yeah, I don't say that anywhere, but I said I would.
Okay. Thank you, timekeeper. You may now remove Exhibit 14. Finally, Mr. Cifuentes, you were in possession of Avery Becker's cell phone on March 5th.
Are you talking about when we were at the Fry Shack?
Yes, March 5th. That was at the Fry Shack.
Yeah, she actually let me play a new game on his phone. It was a super cool game, actually. It was really cool.
Okay. And this was the day, March 5th, before Avery's phone went missing.
Objection, speculation.
Your Honor, this is not speculation in any way. This is a fact that Mr. Becker's phone went missing on the day of March 6th, and March 5th he lost it.
Your Honor, Mr. Cifuentes has no personal knowledge as to whether or not the defendant actually lost their cell phone on that day. It is stated nowhere in their witness statement and nowhere in any examination, and so therefore it is outside of their personal knowledge. So under Rule 602, this is speculation.
The objection is sustained.
Okay. Okay. But you were in possession of Avery Becker's cell phone on March 5th, right?
Objection asked and answered.
Your Honor, I'm simply going back to rebuild foundation after the objection.
Overruled. I'll give you a little leeway, Mr. Evo.
Thank you. And the next day, March 6th, is the day that Coach Brackman died, correct?
Yes, I believe so.
Okay. Thank you, Your Honor. Thank you, opposing counsel. No further questions.
Any redirect, Mr. Holtzinger?
Yes, Your Honor. First, Mr. Cifuentes, did the police accept those screenshots of the text conversation?
Yeah, they did.
And did they ask you to bring your phone to the station at any time?
No.
No further questions, Your Honor.
This witness may step down and the prosecution may call their next witness.
The people of the state of Colorado call Detective Jordan Markowitz. Your Honor, before I begin, may I request how much time I have left?
Yes.
You have 10 minutes, 18 seconds remaining.
Good afternoon. Please introduce yourself to the jury.
My name is Jordan Markowitz, and my last name is spelled Markowitz.
What do you do for a living?
I'm a homicide detective with the Denver Police Department.
How long have you been with the Denver Police Department?
I've worked in the department for 13 years, but as a detective for 7.
Let's talk about some of your qualifications. Besides all the training and certification that you received as a police officer, do you have any specialized training that you use in your detective work?
Yes, I do. I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. For this, I had to complete a 3-day training course as well as pass a certification test where I learned about different types of cell phone data, records, how to use forensic software, things like that. I also had to learn how to acquire and interpret cellular data and records, as well as how to download the contents of a cell phone.
How often do you use your cell phone training?
Oh, constantly. Cell phones are a crucial part of most investigations. I've downloaded the contents of hundreds of cell phones, and I've obtained and interpreted cell tower data in over 50 cases.
And just to wrap up your qualifications here, Detective, did you have any involvement in this case today?
Yes, ma'am, I was the lead detective.
Your Honor, the people of the state of Colorado offer Detective Jordan Markowitz as an expert witness in the field of criminal investigations with a subspecialty in cell phone technology.
Any objection or voir dire from the defense?
No objection or voir dire, Your Honor.
All right, Detective Markowitz will be tendered as an expert in criminal investigations and cell phone technology.
Detective Markowitz, please explain to the jury your involvement in this case.
On Friday, March 6, 2020, a motorist called us about someone who appeared to be passed out on their front porch. We sent some medics, but upon arriving, they found the victim deceased. That's when I was called to the scene, and I arrived around 2:20 p.m.
When you arrived, what did you observe?
I saw the front door was wide open, and the victim was lying face down just inside of his home in a pool of blood. There was blood spatter on the walls, as well as a large bloody knife just next to the victim's body.
Detective Markowitz, please turn to what have been marked as Exhibits 1 and 3. If my co-counsel could put those up on the screen for us. Do you recognize Exhibits 1 and 3?
Yes, I do.
What are they?
They are pictures of the victim's body.
How do you know?
I observed this body at the crime scene.
Are Exhibits 1 and 3 fair and accurate depictions of the victim's body at the crime scene on March 6, 2020?
Yes, ma'am, they are.
Your Honor, the people of the state of Colorado offer Exhibits 1 and 3 into evidence.
Any objection, Ms. Aguirre?
No objection, Your Honor.
All right, Exhibits 1 and 3 will be admitted.
Detective Markowitz, please describe these exhibits to the jury, starting with Exhibit 3.
Well, as you can see, Exhibit 3 is a close-up of the victim's back and stab wound. Exhibit 1 is a photo of the victim's body as viewed from the front porch. You can also see a ring doorbell, in the top right portion of this picture, and Investigator Cusack has already discussed the videos that we've collected from that doorbell.
What did you do after assessing the front of the house?
I went around to the back of the house and into the kitchen, where I observed an open knife drawer as well as a knife block on the counter with one knife missing. By the table, there was a broken plate and overturned chair and drops of blood on the floor, as well as scuff marks by the back door, and all four of these things together indicated that there could have been a struggle.
Based on the physical evidence you found in the home, were you able to form any conclusions as to what happened?
Yes, Mr. Brackman had engaged with an intruder who had broken into the home and had confronted them with a large knife. The intruder somehow gained control of the knife, stabbed the victim, and ran out the front door.
Did the evidence lead you to any conclusions to explain the presence of an intruder in his home?
Well, Mr. Brackman was a lawyer, and it was the middle of a workday pre-COVID, so I concluded it was likely the intruder did not know Mr. Brackman would be inside the house and had entered the home for some reason other than to harm Mr. Brackman. But Mr. Brackman's surprise presence had changed the circumstances.
Did you do anything else to investigate this crime?
I downloaded the contents of Mr. Brackman's phone. When I read the contents of the phone, I found a tremendous number of text and emails associated with the Colorado High School mock trial team. That's how I found out that Brackman was the coach for this team.
What did you do with that information?
I contacted one of the team members, Alex Cifuentes, and got the biggest break in the case.
What do you mean the biggest break in the case?
Well, Mr. Cifuentes had given me the text messages that we saw in Exhibit 14. In them, the defendant basically confessed that it was his intent to break in and trash Brackman's house, which is exactly what he attempted to do.
We believe that the defense is going to offer an expert who will give an opinion that these messages could have been doctored. What is your response to that?
Objection, speculation.
Ms. Kidder, your response?
Your Honor, if opposing counsel could clarify their objection.
You're just assuming as to what we may present in the case where you have no facts or proof of that.
Ms. Kidder?
Yes, Your Honor. We both have the same case, and we are aware of what we believe the defense will try and present, and we need to give rebuttals to their arguments. According to the rules of mock trial, we will not be allowed to recall Ms. Markowitz once Blake Van Owen has testified. And so we are attempting to get this out now while we still can. And according to Rule 611, you control the order of court and you can allow this.
The objection will be overruled. The defense did mention in opening statement that they would be presenting this evidence. So therefore, Ms. Kidder, I will allow you to ask your witness about this.
We believe the defense will try and say that these messages were doctored. What is your response to that?
With all my experience as a detective, I'd be able to tell if evidence was doctored, and I would not have relied on these text messages if they were.
What did you do after you had seen these messages?
Avery Becker became the focus of the investigation because of 1, his expressed intention to break into Mr. Brackman's house, 2, his previous conflicts with Mr. Brackman, and 3, his prior criminal conduct in vandalizing Brackman's car.
Did you ever talk to Mr. Becker to get his side of the story?
I had tried, but he refused. I did get a warrant to search Becker's phone, but when I called to make the arrangements, I found Becker claimed he's lost it the day before the crime. I did get the phone number, though.
What did you do with that information?
I obtained call detail records, or CDRs. CDRs can tell you exactly when and where a cell phone reaches out to a specific cell tower to send or receive a text or call.
What did the CDRs tell you in this case?
They allowed me to see the towers that Avery Becker's phone was connecting to on the day of the murder. This allowed me to conclude that Avery Becker's phone was near Mr. Brackman's house that day. I created a map that shows the basis for this conclusion.
Detective Markowitz, please turn to what has been marked as Exhibit 16. Do you recognize this exhibit?
Yes, I do.
What is it?
It is a map that shows the cell towers Avery Becker's phone pinged off of on the day of the murder. I've also marked the path that he most likely took to get from his home to Brackman's.
How do you know what this exhibit shows?
I created this map with the information I obtained from Becker's CDRs.
Hang on, sorry. Miss Maley? Sorry.
Maybe,
you
yes.
froze for a second? Yeah, if you froze for a second, so if you could go back, start where you started and repeat yourself. I think that way we can make sure.
Of course. With just the previous question or 2 questions back?
No, just when you started talking about the proposed exhibit.
Yes. So as you can see here, this demonstrates the cell phone towers that Avery Becker's phone pinged off of on the day of the murder. And I've also marked the path that he most likely took to get from his home to Brackman's that day.
How do you know what this exhibit shows?
I created this map with the information I obtained from Becker's CDRs.
Is Exhibit 16 a fair and accurate copy of the map you created based off Avery Becker's CDRs?
Yes, ma'am.
Your Honor, the people of the state of Colorado offer Exhibit 16 into evidence.
Any objection from the defense?
No objection, Your Honor.
Exhibit 16 will be admitted.
Detective Markowitz, please explain to the jury what this map shows.
It demonstrates that Avery Becker's phone hit cell towers in a logical sequence that took him from his house to Mr. Brackman's house.
Were you able to form any conclusions based off of this CDR information?
Yes, the defendant was at their home somewhere between 12:45 and 12:50 p.m., as I've marked on the spreadsheet, but then left and drove towards Brackman's house, traveling most likely along Rock Creek Parkway at 12:55 p.m. Then from 1:05 p.m. to 1:17 p.m., Becker was at Brackman's house.
Based off of all of the evidence you collected in this case, were you able to form a conclusion as to what happened in Mr. Brackman's home on March 6, 2020?
Based on all the evidence we collected, the defendant went to the victim's house on March 6, 2020. He broke into the home to vandalize it and was discovered by the homeowner, Mr. Brackman. Mr. Brackman had attempted to use force against the defendant, but he was killed in the struggle.
Finally, the defendant is not charged with premeditated murder in this case. Why is that?
Well, Brackman was a lawyer and it was the middle of a workday. So it's logical for the defendant to assume that Mr. Brackman was not at home because he knew Brackman was a lawyer. I don't believe the defendant would have entered the home if he knew Brackman was inside. He may have even tried to flee when he saw Brackman with a knife. However, a struggle did occur and Mr. Brackman was murdered.
Thank you, Detective. No more questions, Your Honor.
Ms. Aguirre, cross-examination.
Yes, Your Honor. Good afternoon, Detective Markowitz.
Good afternoon.
You headed the investigation for this case, is that right?
Yes, that is correct.
You were in charge of all the decision making?
I was, as the lead detective, that would be part of my job, yes.
Right. Deciding who to talk to?
Talk to as in an interview for my investigation?
Yes.
Yes, that would be correct.
And deciding what potential evidence to gather?
Potential evidence, I just looked at what the evidence was. Potential evidence is a weird way to put it.
But you lost some of this evidence, didn't you?
I personally did not lose any evidence. We had taken pictures of everything at the crime scene, including the blood spatter. Those pictures did become corrupted, but I did not lose them. That would not be my fault.
So they were corrupted, but not at the fault of your own.
That would be correct, yes.
Now, let's start at the very beginning. You were called to Coach Brackman's house to investigate his death, is that right?
Yes, that is correct.
And after a little bit of investigating, you found that he was a part of mock trial.
Yes, when I read the contents of his phone, I found the number of emails and texts related to mock trial.
So the first place you looked into was the high school.
Yeah, I contacted the school to get the contact information for all the students on the team, and that's when I called Alex and got the biggest break.
But you didn't speak to any other student lawyers on the mock trial team.
I had no need to because Alex had given me everything I needed.
If Alex had given you such a big break, you didn't bother looking for any other big breaks?
When you have one big break, there's usually not multiple big breaks in a case. So once I had my big break, that was all that I needed.
So Alex told you about Mr. Becker's dealings with Mackenzie Brackman.
He had showed me the text messages that we saw in Exhibit 14.
Right. So he didn't have his phone, did he?
He had sadly forgotten to bring it with him to the interview, but that's not abnormal necessarily because talking to the police can make people nervous, which can cause them to act differently.
Right. So you told him to go home and send the screenshots when he got there.
Yes, I did.
So you never saw the text with him in person?
I did not see them on his phone because, like I said, he had forgotten to bring it with him, but the screenshots were sufficient, so I didn't need him to come back in again.
You didn't see the text with him in person, yes or no?
No.
Now, I'd like to talk about another part of your investigation. You conducted a cell site data recovery investigation for this case, is that right?
If you're referring to the CDRs, then yes, that would be correct.
Yes. And you concluded with this data, you just testified that Mr. Becker was at Mr. Brackman's house on March 6th.
That is what all the evidence indicates, not just the CDRs, but they do support that.
But does it actually show Mr. Becker at Mr. Brackman's house?
Well, CDRs are not GPS. They cannot give me an exact location. They can give me the specific cell tower as well as the specific antenna on the tower to show the cell phone that pinged off of those specific things, but they will not be able to give me a specific location. Mr. Brackman's home was in the cell tower area that Becker's phone pinged off of, though.
Yes, so it simply shows that Mr. Becker's phone sent a signal to a cell tower in the vicinity of Mr. Brackman's house.
Yes, that is correct.
But based on that data alone, you have no idea who physically possessed the phone on March 6th.
I was not there to witness this crime, so I did not see anyone in the possession of the phone, but all the other evidence indicates that it was Mr. Becker in possession.
But isn't it also true that cell phones don't always connect to the nearest cell phone tower?
While that can be true, it's abnormal. Cell phones will usually connect to the nearest tower because...
Excuse me, that was a yes or no question.
Can you repeat it then, please?
Isn't it true that cell phones don't always connect to the nearest cell phone tower?
Well, that's true, it's abnormal, so yes, but it's not that simple.
Now, after investigating Mr. Brackman's house on the first day, did you go to any other stores or the restaurants that Taylor Perkins and Mr. Becker said they went to?
I did not go to any other stores or restaurants, no.
And didn't you also say in your witness statement that you have downloaded the contents of...
Objection, Your Honor, improper use of a witness statement.
Ms. Aguirre, your response?
Your Honor, I haven't even had the chance to fully ask my question yet.
Ms. Kidder, what is your specific objection?
Opposing counsel just said, didn't you say in your witness statement, witness statements can only be used to impeach or refresh? She cannot quote them directly unless impeaching or refreshing.
Okay, I'll rephrase, Your Honor. I apologize.
All right, thank you.
Didn't you testify earlier that you have literally downloaded the content of hundreds of cell phones?
Yes, I have in previous investigations.
But you didn't do that for this case, did you?
For which phone are you referring to? There were multiple cell phones involved.
For Mr. Becker's phone?
So in order to download the contents of a cell phone, I would have to be in possession of the cell phone. But because Mr. Becker claimed to have lost the cell phone the day before the crime, I would have no way to download the contents of his cell phone.
Sorry, I meant Miss Perkins' cell phone.
I did not obtain Miss Perkins' cell phone either. I actually didn't even speak to Miss Perkins. Someone else on my team did.
Okay, well, after investigating the house, you didn't go to the Fry Shack to see if Mr. Becker or Miss Perkins had been there to confirm their alibi.
I would not know who would be at the Fry Shack, if it would even be the same workers or same people there. So I didn't go to the Fry Shack to do that.
Now, lastly, I'd like to talk about the people you investigated in this case. You said that it was highly unlikely that Mr. Brackman's mock trial activity had anything to do with his death. Is that right?
That was my first thought upon learning he was the coach for this team, but upon further investigation, all the evidence clearly indicated that it was Mr. Becker, which would in fact relate to mock trial.
But didn't you also say that it could have been the work of one of his disgruntled ex-clients?
Yes, but I concluded that that was highly unlikely because of where the evidence took me.
Just a yes or no, please.
Yes.
Thank you, Your Honor. No further questions.
Ms. Kidder, any redirect?
Yes, Your Honor. Detective Markowitz, did you only look for the evidence you wanted in this case?
Absolutely not. I looked at all the evidence and followed it where it took me, as any good detective would.
And finally, you were cut off multiple times during that cross-examination. Is there anything else you would like to clarify for the jury or an answer you would like to finish?
I believe that I have presented all of the evidence that I needed to in this case, so I would say no, but thank you.
No further questions, Your Honor.
All right, does the prosecution have any further witnesses?
The prosecution rests, Your Honor.
Defense may call their first witness.
We call Mr. Becker to the stand.
Ms. Aguirre, you may proceed. I'm sorry.
No worries. Good afternoon, Mr. Becker.
Good afternoon.
Could you please introduce yourself to the jury?
Hello, my name is Avery Becker. Last year I was a senior at Colorado High School.
And what did you like to do as a senior at Colorado High School?
You know, I love doing what most kids love doing. I loved hanging out with my friends, and me and one of my best friends, Taylor, decided to do mock trial, which I love now too.
Could you tell us about your experience with mock trial?
Yeah, I mean, I really liked mock trial. It meant a lot to me, and I loved that I was able to hang out with my friend Taylor.
Did you have any difficulties with mock trial?
You know, overall, I had a really amazing experience, really. But sadly, me and my coach, Mr. Brackman, didn't always see eye to eye. And, you know, I wish that could have been different.
Other than that, did you like your team?
Yeah, I really liked my team. And I even liked Mr. Brackman. I mean, despite our differences, Mr. Brackman did make the team much more competitive, and he got us to the top. And, you know, I loved hanging out with Taylor as well, who was on the team with me.
Did anything ever happen between you and Mr. Brackman?
Well, you know, tensions were high between us some of the time, and sometimes we'd get in arguments. Probably our biggest argument was just after regionals.
What happened?
Well, as I said, it was just after regionals, and I thought I had done really well, actually. I was pretty proud of myself. I won best closer, and I'd also won best attorney. And I was pretty proud of myself. But Mr. Brackman seemed really angry at me, and he told me that I didn't deserve my awards, and I wasn't going to be any good at state. I, I was embarrassed. I mean, I rushed out of practice, and what I did next was the stupidest thing I've ever done.
What did you do?
Well, it was a complete accident, but I accidentally drew on his car. I thought it was a dry erase marker, and we had been using dry erase markers at the practice, and so I thought it was a dry erase marker, but I just thought it was going to be a harmless prank, but it was a permanent marker, and when he found out what I had done, he kicked me off the team.
So, did you intend to cause harm to Coach Brackman's car?
No, I thought it was a harmless message. Really, I thought it was a dry erase marker. It was a complete accident. I would never do anything to hurt Mr. Brackman on purpose.
Did you tell anyone about what happened?
I talked to my mom about it afterwards, and she told me to do the right thing, which was to apologize. And so I went to his office and tried to apologize in person, but he wouldn't see me. And I tried texting him. I offered to get a job and try and pay for repairs. I offered to try and fix it, but he just ignored me.
Thank you, Avery. I'd like to talk about the night before the accident. That was March 5th. Do you remember what you were doing that night?
Yeah, I was hanging out with my friend Taylor. We went to the Fry Shack, which is this little place that all the CHS kids go, and it's so fun. We were playing on our phones, and I got distracted by the mock trial team that came in after I was kicked off the team, and then I left for home.
How about the next day? What did you do?
Well, I must have left my phone somewhere the day before, so I skipped school with Taylor to go and try and find it. I had Taylor call my phone a bunch, and we spent all day retracing my steps trying to find it, but we never did. I actually had to get a new phone.
So, when did you hear about what happened to Mr. Brackman?
Well, I heard that something had happened to him at the end of the day, actually. I went to the Fry Shack retracing my steps with Taylor, and the mock trial team was there again. And they said that Mr. Brackman wasn't at practice for some reason, which is really, really weird.
Thank you, Avery. I'd like to talk a little bit more about the allegations against you. Earlier in court, you heard Ms. Cifuentes testify about the text messages you'd sent.
Yes.
Your Honor, permission to bring up previously admitted Exhibit 14?
Permission granted.
Timekeeper, if you could pull those up. Okay. Do you recognize those texts that you saw earlier? Oh, okay, hold on. Do you recognize these texts?
No, I've never seen those texts. Certainly have never sent them before. I would never do that. I mean, me and Alex weren't exactly friends.
So, how would you describe your relationship with Alex?
Well, really, we just knew each other through mock trial. I mean, we were just kind of polite to one another.
Thank you, Timekeeper. You can take those down. And earlier in court, you saw the ring videos as well?
Yes.
Was that you in the ring videos?
No, of course it wasn't me. That was just some guy wearing a mask, and I didn't even know where he lived. I would never do anything to hurt Mr. Brackman. I didn't want to do that.
So, did you enter Mr. Brackman's house on March 6th?
No, no, of course not. Again, I didn't know where he lived. I didn't want to hurt Mr. Brackman. I wanted to apologize to him.
And lastly, if you were able to contact Mr. Brackman on March 6th, what would you have wanted to say to him?
Ms. Wind, I think you're still on mute, but I think you had an objection.
Yes, Your Honor, speculation. This information is outside of the witness's statement. The attorney is asking this witness to merely speculate about what he might have said, and therefore this is not admissible.
Your response, Ms. Aguirre?
It is the witness's state of mind at that time, and just to give just a final statement as to what he might have been able to say.
The objection is well taken, but I will overrule it at this time.
May I re-ask the question, Your Honor?
Yes.
Lastly, if you're able to contact Mr. Brackman on March 6th, what would you have wanted to say to him?
I would have said, I'm sorry. I'm sorry for everything that I did. I'm sorry that I ruined your car. I'm sorry that I wasn't a great mock trial student. I wish that things could have been different between us.
Thank you, Your Honor. No further questions.
Ms. Wind, cross-examination?
Yes, Your Honor. All right. Mr. Becker, excuse me. You just gave that very nice statement about what you would have told Mr. Brackman had you been able to. If my co-counsel could please pull up your witness statement, it should show up on the screen in front of you. Now, right there at the top, it says Avery Becker witness statement. And then if you go down to the last page, that is your signature down there, right?
Yes.
Do you know where in your witness statement you say those words about apologizing to Mr. Brackman or any of the things you just said?
Yes, I say that I wanted to apologize to him after I heard
But
his
you
call.
never actually said those words, did you?
What do you mean?
You just gave us this whole speech about how you would have said how you were sorry. You never said those words in your statement.
Sorry, Ms. Wind, I think Ms. Aguirre is trying to make an objection. If you could pause for a moment. Ms. Aguirre?
Your Honor, you granted me and my witness, Mr. Becker, the ability to say that in court today, and therefore we could say this.
So what's the objection?
My objection is that this is just, she can't, we just had an objection talking about how it's okay that if Mr. Becker did testify about what he would like to say to Mr. Brackman, even though it could be outside his scope.
Well, while that's true, it's also true that Ms. Wind, there's nothing in the rules of evidence that prohibits Ms. Wind from following up on that and asking questions about that, since that occurred during direct examination. So I'll allow her to continue with her questions.
Yes, Your Honor. I believe we have sufficiently established that those statements that you just made, Mr. Becker, are not in your witness statement, so I will continue. Now, about your relationship with the victim, Mackenzie Brackman, it's your statement in court today that you hated him, right?
No, I didn't hate him. We had disagreements at some times.
Mr. Becker, excuse me. I'd like to direct your attention once again to your witness statement, which you have already testified is yours. Line 138, page 38. And right there, I believe it says, Alex and Blair were friends in high school, and Blair's the one person that hated Mr. Brackman more than I did. Did I read that correctly?
It does say that Blair hated Mr. Brackman, yes.
And he hated him more than you hated him, right?
I strongly disliked him, but I mean, Blair did hate him more than I did.
And again,
Doesn't
in
say
your
that I
own
hated him.
words, I'm going to continue, Mr. Becker. In your own words, Mr. Brackman hated you as well, right?
He did hate me. I'm not sure why.
Let's discuss some of the reasons for this mutual hatred. You have previously said that Mr. Brackman was always critical of you, right?
Yes, he was.
And you've also said that his role was simply to attack you, right?
It seemed that way.
Mr. Brackman would go nuts whenever you didn't do what he wanted, right?
Yeah.
And you argued with Mr. Brackman at almost every practice, right?
Yeah.
Mr. Brackman called you lazy, right?
Yeah.
And you said to your adult coach that he wouldn't know a good cross-examination if it hit him over the head, right?
Yes.
And Mr. Brackman didn't just criticize you privately, he did it in front of the whole team, right?
Yeah.
And in addition to these bad feelings about one another, several times your arguments went farther than just words, right?
It did happen.
Number one, before the regional tournament 2020, Mr. Brackman demoted you from the A team down to the B team, right?
Yeah.
And number two, when you won an award at regionals, Mr. Brackman criticized you and you called him the worst coach in the state, right?
I did in the moment, yes, but he did get us to a higher standing and did make our team much more competitive.
But after you said that to him, you took some sort of marker and drew worst attorney award on the hood of his car, right?
Yes, it was a complete accident. I didn't mean to. I thought it was just a dry erase marker.
But you know that vandalism is a crime, right, Mr. Becker?
It was an accident. I thought it was just going to wipe right off.
But you did draw on his car, right?
On accident.
And number three, on the spot, when Mr. Brackman saw what you had done, he immediately kicked you off the team, right?
Sadly, yes.
And on that occasion, in your own words, he yelled, "What the hell have you done to my car? That's it. I have had enough of your crap. You don't work, you screw around in practice and are disruptive. You talk behind my back, and now this. I have had it. You are off the team." Those were his words, right?
Object. Hearsay.
Process win?
I said hearsay.
Yes,
Yes,
and
may I continue?
yes.
These are not hearsay because they are simply being offered for the effect on the listener and the feelings that Mr. Becker had after Mr. Brackman yelled him at this. We are not offering this for the truth of the matter in any way, but simply the effect for the listener, and therefore they are not hearsay.
The objection's overruled.
So those were his words to you, right, Mr. Becker?
They were.
In your own words, that made you madder than getting criticized in front of the whole team, right?
It made me angry, yeah.
Finally, Mr. Becker, immediately after you got kicked off the team, you went home and told your own mother that Mr. Brackman got mad at you for no good reason, right?
I was caught up in the moment, yes.
So you didn't tell your mother the truth. You lied to your mother, right?
Again, I was caught up in the moment. I wasn't thinking straight.
But just to be perfectly clear, Mr. Becker, you did not tell your mother the truth, yes or no?
I guess not, no.
But you did tell your mother, and I quote, that you would get back at Mr. Brackman if it was the last thing you did. Those were your words, right?
I, again, was caught up in the moment and I felt differently.
But
very
Mr.
soon
Becker,
after.
Mr. Becker, those were your words, right?
At the moment.
Thank you. I have no further questions, Your Honor.
Any redirect, Ms. Aguirre?
No redirect, Your Honor.
The defense may call their next witness.
Your Honor, the defense calls Taylor Perkins to the stand. Your Honor, may I proceed?
You may.
Good afternoon, Ms. Perkins.
Good afternoon.
Can you please tell the jury about yourself?
Yes, my name is Taylor Perkins. I'm currently a freshman at CU Boulder, but last year I attended Colorado High School.
Did you participate in any activities in high school?
Yes, I did actually. I was a part of the mock trial team with my best friend Avery.
And who is the coach of this team, Ms. Perkins?
It was Mackenzie Brackman.
Now, how was your overall experience on the mock trial team?
At first it was good, but later it became a bit more uncomfortable. There was just a lot of tension between Coach Brackman and Avery. They had different ways of approaching and different learning and teaching styles.
So what happened?
Well, their relationship just seemed to get worse. A month before regionals, Avery showed up the most unprepared he had to practice. And I mean, even then he improvised really well, but Coach Brackman got really upset and he demoted him to B team.
And how did you perceive Avery react to this demotion?
I mean, Avery was reasonably upset. He seemed to be upset. I mean, it was his senior year. And sure, he hadn't showed up prepared, but he had been working 4 years to be on A team.
Now, what were your thoughts on Avery's demotion?
I mean, I thought it was really unfair, not only for Avery.
Objection relevance.
Mr. Ebel?
Your Honor, this is relevant because this is my witness talking about a relationship that she had with Mr. Becker, and it is building the foundation for later questions on in the testimony.
Your Honor, I believe this question called for Ms. Perkins to testify as to how she felt about her friend's demotion. I don't believe that that goes to the relationship between her and the defendant because it goes simply to her own feelings, and her feelings are irrelevant in proving any case that is relevant to this case. So therefore, this is not relevant.
The objection is well taken, but I will give Mr. Mr. Ebel a little leeway to lay foundation as the witness's credibility is a relevant question in this case, but just a little leeway.
Thank you, Your Honor. Your Honor, may I re-ask the question?
You may.
Ms. Perkins, what were your thoughts on Avery's demotion?
I mean, I thought it was very unfair, not only for Avery, who was so passionate about mock trial, but for the rest of our team too. I said that I didn't think we would.
Objection, hearsay.
Response, Mr. Ebel?
Your Honor, under the exception to hearsay, this is my witness's then existing mental state, and because that is the case, therefore it is an exception to hearsay.
Mr. Holsinger?
Your Honor, under Rule 8033, the then existing mental, emotional, or physical condition exception is only a statement of a declarant's then existing state of mind or emotional, sensory, or physical condition. I believe that no foundation has been laid that that was the case in this statement from Ms. Perkins, so therefore this exception doesn't qualify.
Mr. Ebel, if you would lay a little more foundation before she testifies about her mental state.
Okay. Ms. Perkins, what were your thoughts on the demotion overall?
Yeah, as soon as I heard about him being demoted, I believed that we wouldn't be able to make it to regionals without him.
Okay, so what did you do?
I decided to step down from the team. I mean, mock trial didn't really mean that much to me, and I didn't want to do it without a friend on the team. So I stepped down, and Avery was able to come back on the team after that.
Now, what were the effects of these two changes to the composition of the mock trial A team?
Well, it was a week before regional, so Coach Brackman didn't really have another choice but to let us back on the team.
And what did that mean for the team?
Well, I think it proved to me that I had made the right choice. I mean, we did really well in regionals, and Avery won 2 awards.
Now, did you perceive that these awards had any effect on Avery's dealings with Coach Brackman?
Objection, speculation.
Your
Sustained,
Honor,
could you?
my witness has not even. Your
Sustained,
Honor, the question that I asked was.
Sorry, I think we
Sorry,
keep talking
you keep
over each
cutting
other.
out for me. Can you repeat what you said?
Yes, I sustain
Sorry.
the objection. If you would rephrase, please.
Okay. Yes, Your Honor. Now, did these in any way affect Avery's dealings with Coach Brackman?
Objection, speculation. This is still speculation because Ms. Perkins established that she was already off the team. So this is a speculation pursuant of hearsay because the only way that she would have knowledge of this is through hearsay. So I'd say speculation for this.
Through hearsay or speculation?
Speculation.
Okay. Your Honor, what my witness is going to testify about is just her rationally based perception and what she observed between her mock trial coach and her best friend. So therefore, she is allowed to testify about her rationally based perception. She's not going to testify about anyone's feelings, but just her perception of what was going on between the two of them.
Your Honor, it's been established. Sorry, may I be heard?
No, Mr. Holsinger. Based on that proffer, your objections are overruled.
Thank you, Your Honor. So may I re-ask the question, Your Honor?
Yes.
Thank you. Now, Ms. Perkins, how did the awards affect Avery's dealings with Coach Brackman?
Well, it wasn't at all what you'd expect. I would have expected Coach Brackman to be proud of him or to congratulate him. But instead, he said that he didn't think Avery.
Objection, hearsay.
Mr. Bell.
Yes, Your Honor. This is not hearsay, as what my witness was about to say was for the effect of the listener. We were not using the information to prove the truth of the matter asserted. So therefore, it is not hearsay in this situation.
All right, the objection is overruled.
Thank you, Your Honor. Your Honor, if I may re-ask the question again.
Yes.
And how did this affect Avery's dealings with Coach Brackman?
I mean, it just deteriorated their relationship. He told him that he didn't deserve any of his awards, which made Avery really upset. I mean, he seemed to be really proud of himself, like anybody who received awards would be. So on his way out that day after practice, he grabbed what he later told me he believed was
Objection, lack of foundation.
May I ask what opposing counsel is objecting to for lack of foundation?
Your Honor, it's been established that Ms. Perkins was not on the mock trial team when all of this took place, as she quit the mock trial team for the defendant to be put back on the A team, which means that anything relating to this day, because Ms. Perkins was not there, there's been no foundation that has been laid that she knew about these events.
Mr. Bell, can you ask the witness how she knows first, and then I can address from there.
Okay. Yes, Your Honor. Well, actually, Your Honor, we just mentioned this when opposing counsel objected to hearsay, and it was the exception that was Avery talking to her about what happened at the practice. So therefore, it has already been established that what she is talking about is secondhand information from Avery. Would you still like me to re-ask the question or lay more foundation?
No, thank you for reminding me. Based on that, the objection is sustained.
Okay, I'll just move on, Your Honor. Ms. Perkins, how, if at all, did Avery respond to this criticism?
Yeah, Avery was really upset, and unfortunately on his way out, he grabbed what he thought was a dry erase marker and he wrote on Coach Brackman's car.
Your Honor, once more, I object to lack of foundation. The witness's personal knowledge of these events only comes from either hearsay or speculation. Neither of those have been laid, so I'd say that improper foundation has been laid for her to testify about this.
Response, Your Honor.
The objection's overruled. You may continue.
Thank you. May I re-ask the question?
Yes.
Thank you. So, Ms. Perkins, how, if at all, did Avery respond to this criticism?
He was clearly really upset, and unfortunately, on his way out, he grabbed what he thought was a dry erase marker and he wrote on Coach Brackman's car.
Well, what happened next, Ms. Perkins?
Well, after that, he tried apologizing over and over again to Coach Brackman, but he wasn't having it, and he was kicked off the team.
Did Avery ever try to get back onto the team?
Yes, he did. He tried reaching out to other teammates to see if they would talk to Coach Brackman, and he went to a practice too to apologize in person, but he was asked to leave.
What happened after Avery was asked to leave?
Well, after that, he came over to my house where we were playing some games, and then after that, we decided to go to the Fry Shack for dinner.
Now, what was the dynamic like at the Fry Shack?
I mean, it was good at first, but it ended up not being the wisest decision because as we were finishing up dinner, the mock trial team came in from after practice and it became a bit awkward. I mean, Avery had just gotten kicked off the team, so it really upset him seeing everybody there. Even though most people were supportive and they told him that they would talk to Coach Brackman to try to get him back on the team. But Avery was clearly upset.
What happened next at the Fry Shack?
Well, Alex Cifuentes actually came over and he was telling Avery how bad he felt about him getting off the team, but it seemed really insincere and it just seemed to upset Avery even more. So he actually stormed off to the bathroom after that and he left his phone behind on the table.
Now, when did you realize that Avery lost his phone?
We both realized the next morning.
What did you do?
Well, I suggested that we should spend the entire
Objection, hearsay.
Overruled.
Thank you, Your Honor. May I re-ask the question?
Sure.
Ms. Perkins, what did you do after you found out that Avery lost his phone?
I suggested that we go look for it. So we retraced our steps. We went to the mall, we went to the Fry Shack, and we searched for his phone everywhere.
Did you ever find his phone?
Unfortunately, we did not.
How long did you search?
We searched all day.
And was Avery with you the entire time?
Yes, he was.
So please describe your interview with the police to discuss Mr. Brackman's death.
I did not have an interview with the police.
How many times did the police call to set up an interview with you?
The police did not set up an interview with me.
Well, how many times did the police email you to set up an interview?
Once again, that didn't happen. They didn't communicate with me.
So, to the best of your knowledge, did they learn about your activities to track down Avery's lost cell phone?
No, I don't know how that would have been possible.
To the best of your knowledge, did they learn that you'd spent this time with Avery on the day that Coach Brackman died?
They did not.
Thank you, Your Honor. No further questions.
Mr. Holtzinger, cross-examination.
Yes, Your Honor. Ms. Perkins, I have some questions for you as well. First, let's talk about what you said on direct. You talked a lot about the night that Avery got kicked off the team, but you weren't there, were you?
No, I wasn't. I heard about it.
And you also weren't there when Mr. Brackman kicked the defendant off the team, right?
No, I wasn't.
I'd like to discuss your friendship with the defendant as you testified on direct. First, you'd say that you're best friends with the defendant, right?
Yes, we were.
But it's also true that you think the defendant was rash and had an inflated ego, right?
Sure, at times. I mean, like any of us.
You spoke with the defendant pretty frequently, didn't you?
I mean, we were friends, so we did. And we were on mock trial. We went to school together. Yeah, we communicated.
In fact, even after you found out that you were going to be a witness at trial, you were able to get together with the defendant and talk about the day of the murder, right?
I mean, Avery did mention it to me.
But you were able to get together and talk about what happened on the day of the murder after the fact?
I wouldn't say we got together, but we did talk about it.
Let's talk about Mr. Brackman. The defendant didn't like Mr. Brackman, did he?
No, I mean, they didn't get along.
You also didn't really like Mr. Brackman, did you?
Well, I didn't think he always made the best choices for our team.
Yeah, you didn't make the best choices. You considered him to be a mediocre coach because of that, right?
Yes, I did.
You also thought he was a pretty mediocre lawyer in real life, right?
I think that could be true. I mean, if he didn't make the best choices for us as our team,
And oh, sorry. Mr. Brackman once demoted the defendant to the B team, right?
yes, he did.
And you quit the A team after that, right?
Yeah, I stepped down. I mean, mock trial wasn't that important to me. I don't even want to be a lawyer.
And after you quit the team, the defendant was put back on the A team, right?
Yes, we were both put back on the A team.
And like we discussed before, the defendant destroyed the paint on Mr. Brackman's car, right?
Unfortunately, he did. He had believed it was a dry erase marker, but it ended up being a permanent marker. He felt terrible.
But you'd agree with me that he destroyed the paint on the car because he wanted to let off steam and freak Mr. Brackman out. Is that correct?
I mean, it wasn't intentional, but unfortunately, that was the result.
But you would say that he destroyed the paint because he wanted to let off steam and freak him out, right?
No, I mean, he didn't mean to destroy the paint. That wasn't the
Ms.
intention.
Ms. Perkins, you wrote a witness statement for this case, didn't you?
Yes, I did.
Can we pull up that witness statement? On the last page of that witness statement, do you see your signature at the bottom of the page?
Yes, I do.
And right above that, read along with me. I have carefully reviewed this statement. It is true and accurate and includes everything I know that could be relevant to the events I discussed. Did I read that correctly?
Yes.
All right, let's turn to lines 41 and 42, please. I'll ask you to read along with me. Avery just wanted to let off steam and freak Coach Brackman out. Did I read that correctly?
Yes, that's correct.
All right. And on the spot, after the defendant destroyed the paint on Mr. Brackman's car, he kicked the defendant off the team, right?
Yes, he did. So Avery
And
did do that, but I don't believe his intention to destroy the paint. I mean, he couldn't have known that it would destroy his paint if he thought it was a dry erase marker.
all right. And after the defendant destroyed the paint on Mr. Brackman's car, the defendant lost her last opportunity to be on the team, right?
I mean, I don't know if he was aware of that. He tried getting back on the team. He reached out to teammates. He went to apologize.
Did the defendant ever make it back on the team?
No, he didn't.
Let's discuss your story about the day of the murder. You have stated that Mr. Becker is so connected to his cell phone that it is like his third kidney. It was never out of his reach, right?
Yes, that's true, which I think just goes to show how upset he was that day.
Yeah, let's talk about that. It's your testimony that the defendant left the fry shack for whatever reason without his cell phone, correct?
I think that may have been true. I mean, last
And
time I remember seeing it was on the table. I don't recall if he grabbed it after that.
all right, well, regardless of if he grabbed it or not, he also spent the entire evening at his home without his cell phone, right?
Yes.
He also spent the entire morning and got ready for school without even trying to look at his cell phone, right?
I suppose that's true. I mean, we both realized the next day.
Yeah, only after all of this, only after he picked you up to go to school the next day, only then did both of you realize that he didn't have his phone, right?
Yeah, we did. I had been texting him in the morning and I found it weird that he hadn't answered me. So when he picked me up, I asked him about it and that's when we both realized it had been missing.
And this is despite the fact that his phone was never out of his reach.
Yeah, like I mentioned, he was really upset.
No more questions, Your Honor.
Mr. Ebel, any redirect examination?
No redirect, Your Honor.
All right, this witness may step down and the defense may call their next witness.
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand. May I begin, Your Honor?
You may.
Good afternoon, Professor Van Owen. Would you please introduce yourself to the court?
Yes, good afternoon. My name is Professor Blake Van Owen, and I teach and study criminal justice.
And how did you find yourself working in this area of criminal justice?
I've sort of always felt drawn towards criminal justice, and I've always wanted to make a positive impact into my community. So I became a police officer, but I left the force after about 9 months when I realized that there were multiple practices with which I disagreed, and I couldn't be a part of it anymore. So I guess I left to pursue a career that felt more like I was actually helping people.
And what sort of things did you pursue to this end?
After I left the force, I worked a few jobs. I worked as a school resource officer. I went into private security, but then I started teaching classes on police procedures for more than 5 years.
And since then, did you continue teaching? Did you learn anything else? What have you been doing with your life?
I went back to school and I've received my master's in criminal justice, and I have continued to teach. And I've begun work as a private investigator for cases like these where I'll testify as an expert.
And what areas have you testified as an expert in before?
Well, I've testified regularly as an expert in crime scene reconstruction, cell tower data analysis, and general police investigation.
And when you say regularly, Professor, what do you mean by that?
Well, I've testified in these areas more than 5 times, and in multiple states. I think Colorado, Nebraska, Arizona, New Mexico, and Wyoming.
And Professor, just briefly, you mentioned cell tower analysis. Do you talk about this in your report for this case?
I do. I mention this a bit in my report. I mention how I talk about cell towers and how your phones connect to them, about the different sectors of the tower and the mathematics behind it.
Would you say just a little bit about those mathematics?
Yes, a cell tower is divided into
Your Honor,
three.
under the best evidence rule, if they would like to talk about this evidence, they must admit that previously.
Your Honor, I would say that this isn't evidence for this case, and this is just Professor Van Owen's knowledge about cell towers. We're simply trying to lay foundation for Professor Van Owen's expertise.
Ms. Karen, any response?
Your Honor, I still believe if they would like to talk about the specific details of that exhibit, it needs to be admitted into evidence previously.
All right. The objection's overruled. I'm going to give you a little leeway since you're laying foundation, but try not to get too specific into details because Professor Van Owen has not yet been tendered as an expert.
Yes, Your Honor. Professor, would you share just a small bit about the mathematics of cell towers?
Yes, well, I talk a bit in my report about how you find the area of that these cell towers cover, and the equation is very similar to like what you would see in algebra course. You take the radius of that area covered by the cell tower and you put it into the equation pi r squared, and to find the area of the sector, you would divide it by 3.
Thank you, Professor. Your Honor, I move to tender Professor Blake Van Owen as an expert in 3 fields: in crime scene reconstruction, cell site analysis, and general police practices.
Ms. Kidder, any voir dire or objection?
Yes, Your Honor, we object to the crime scene reconstruction portion of that. Ms. Van Owen cannot lay any foundation to being a crime scene reconstructionist.
Your Honor, may I respond?
Yes.
Pursuant to Rule 702, an expert needs skill, education, experience, training, or expertise to be found as an expert in any field, and they don't need all 5 of these. Any one of these will do. Professor Van Owen has testified that she's been accepted as an expert in the field of crime scene reconstruction more than 5 times in multiple states, and to have been found as an expert in this area in more than five times in multiple states. That implies that she does have the requisite skill, education, experience, and training. It also implies that she's worked with crime scene reconstruction in these cases, which would imply the experience and knowledge and training to be found as an expert.
Ms. Kidder, any additional reply?
Yes, Your Honor. Although it is true that under Rule 702, they can be admitted under knowledge, skill, experience, training, or education, previous testimony is not one of those areas, and Ms. Van Owen cannot testify to any specific knowledge, skill, experience, training, or education in crime scene reconstruction.
While the objection is well founded, I am going to tender Ms. Van Owen as an expert in the 3 fields, and Ms. Kidder, you may on cross-examination, if you'd like, further go into her background so that the jury may consider that in terms of determining the weight of her expert testimony.
Thank you, Your Honor. Now, Professor Van Owen, let's just start broad. What is the biggest takeaway you have from your time spent looking at the investigation done on this case?
Well, to put it simply, this was a rushed investigation. It was filled with mistakes, and the police chose their suspect before they even really started their investigation.
Would you elaborate on that last statement?
Well, the first place that the police looked into was the high school mock trial team, where they heard from Alex Cifuentes about Avery Becker. From this point on, they didn't look into any other suspects, so they essentially conducted this investigation with only Mr. Becker in mind.
Thank you, Professor. Now, you mentioned a few other conclusions about the case being rushed and filled with mistakes. What other parts of Detective Markowitz's investigation led you to those conclusions?
Well, you've already heard from the prosecution about these text messages that supposedly show Mr. Becker's intent to break into Mr. Brackman's home. However, it's my belief that you were misled as to the legitimacy of these text messages.
And what is your opinion on the legitimacy of these text messages?
Well, these texts are actually screenshots sent to the police department by Alex Cifuentes. The police could have easily checked to see if these text messages were in fact, or these screenshots were in fact a accurate, real text message conversation that occurred. They have this special software called Celebrate, which pulls all the data off of a phone and they can authenticate it. But Detective Markowitz chose not to.
Thank you, Professor. Now, I'd like to talk about another part of the investigation, the cell site investigation done by Detective Markowitz. What are your thoughts on this part of their investigation?
Again, you were presented with cell site data, but again, in my opinion, you were misled as to how cell towers actually work. The prosecution looked at the cell site data and said, if Mr. Becker's phone pinged off of these towers, then obviously the phone was there and obviously Mr. Becker was there. But that's simply not how they work.
Now, what is your opinion on how cell towers work and the accuracy of the cell site data?
Well, you could be standing right next to a cell tower and still connect 1 mile away because your phone isn't designed to connect you to the closest tower. It's designed to connect you to the tower that will get you the best signal. So just because Mr. Becker's phone pinged along these towers, that certainly doesn't mean the phone was there, and it certainly doesn't mean Mr. Becker was there.
And why does it certainly not mean that Mr. Becker was there?
Well, you've already heard both Avery and Taylor testify to the fact that Avery had lost his phone and that they were looking for it that day. I mean, anybody could have had it, and that route that the phone supposedly went along is a major walking route comprised of several major roads whose sole purpose isn't only to get to Mr. Brackman's home.
Now, Professor Van Owen, I'd like to talk about one other part of the prosecution's case today, the crime scene reconstruction done by Kyle Kuzak. Would you tell us your opinions on Miss Kuzak's reconstruction?
Well, in their investigation, Kuzak came to a lot of unsupported assumptions. For example, Kuzak opines that these scuff marks found on the kitchen floor are somehow indications of a struggle, but there's no way to prove this. Their story also hinges on Brackman both having heard Ring doorbell notifications and have grabbed a knife in self-defense. But again, there's no way to prove these claims.
Now, Professor Van Owen, as someone who has done crime scene reconstruction work, I'm sure you can agree that part of Miss Kuzak's job is to make some assumptions. Why did these assumptions trouble you so much?
These assumptions that she made didn't seem to fit much with the physical evidence, but instead seemed to fit remarkably well with what Detective Markowitz believed to have happened at the scene of the crime. And I'm just troubled by how this reconstruction wasn't completed solely off of evidence, but seemingly to align with the prosecution's version of events.
Thank you, Professor. Now, you also completed your own reconstruction of the scene. Is there anything you'd like to tell us about that?
I actually don't feel that my reconstruction is all that important, because I don't think it matters the exact way in which Mr. Brackman was stabbed, because it's my opinion that Mr. Becker wasn't even at the scene of the crime at all. I mean, I really think the thing to focus on here is that Miss Kuzak's investigation was filled with assumptions, and there's no certainty that their conclusions even led to Mr. Becker.
Thank you, Professor. Now, on the subject of your own conclusions, you mentioned earlier that the prosecution, that Detective Markowitz never looked into any other suspects. Did you investigate other suspects where they did not?
Well, I can't point to anybody with 100% certainty, but I'm sure there were multiple other people at least worth looking into.
And what do you mean by that?
Well, as a defense attorney, it's likely that Mr. Brackman had many disgruntled clients and families of clients. In particular, a student named Blair Rollins, who was actually absent the same day as Avery and Taylor.
Would you tell us
I'm sorry to interrupt you, but the judge got kicked out, so hold off for 1 second until
pause
she can
the
get back
time.
in.
Thank you, Professor. We'll just breathe in and out, take a quick moment to collect our
Sorry,
thoughts.
because we're on a roll.
It's all good. This is part of Zoom mock trial.
Right. Brave new
Okay.
world.
Am I back?
I can hear you, Your Honor.
Yeah, there
Okay.
you are.
Sorry. My Wi-Fi has gone out, so I'm using my phone, but I am back. So I apologize.
Thank you.
Where would you like us to start, Your Honor?
Just wherever you stopped, whenever you first noticed that I was no longer there.
Did you hear the name Blair Rollins before you left?
I don't think so.
Okay, Your Honor, I would ask
So.
that we might have 15 to 20 extra seconds added just to repeat that one question so you can hear Professor Van Owen's testimony.
Yes, that's fine. I'll give you 30 seconds since I gave the prosecution 30 seconds for their technical difficulty, so I'll do the same for you.
Thank you, Your Honor. Now, Professor Van Owen, you said that there could have been multiple other suspects worth looking into. What did you mean by that?
Well, as a defense attorney, it's likely that Mr. Brackman had many disgruntled clients or families of clients, in particular, a student named Blair Rollins, who goes to the same high school as Avery and Taylor and was in fact absent the same day as them.
Would you tell us more about Blair Rollins?
Yes, well, Brackman worked as an attorney for their father, who ended up convicted by the jury. I believe he got sentenced to life in prison, and I can't tell you if Mr. Rollins committed this crime, but there's just as much cause, if not more so, to look into Blair Rollins, yet the police never even considered them an option.
Thank you, Professor. Just one final question. Has there been anything presented in court today that would lead you to believe or change your conclusion about whether or not Avery Becker was in fact at 444 South Flower Street on March 26th?
Absolutely not. I can't tell you who did it, but what I can tell you is that the only evidence that the police were able to find that could possibly point to Mr. Becker as the intruder were misleading cell site data from a phone that Mr. Becker didn't even have, and a highly questionable, unauthenticated text message conversation that we can't even be sure ever actually happened. So no, I don't think they did.
Thank you, Professor. Thank you, Your Honor. No further questions.
All right, Ms. Kidder, cross-examination?
Yes, Your Honor. Before I begin, may I ask how much time I have remaining?
You may.
Yes, you have 8 minutes, 12 seconds remaining.
Professor Van Owen, I would like to start off with your CSR information. You cannot testify to any specific knowledge, training, experience, skill, or education in the field of crime scene reconstruction. My apologies. Can you?
I don't mention it specifically in my statement, but if you would like me to talk about it, I'd be happy to.
No, that's exactly my point, Ms. Van Owen. You did not mention that in your witness statement. Now I'd like to talk to you about who's paying you in this case. In your entire career, having worked on 100+ cases, you've only ever worked for criminal defendants. Isn't that right?
Yeah, I get this question a lot. The prosecution tends to use their own in-house witnesses, like crime techs, people who already work for the police or the state.
Yes, but the prosecution, you are aware that the prosecution can hire individual witnesses if they would like, aren't you?
If they would like to, but they tend not to.
And in your entire career, having worked 100+ cases only for defense, you typically charge between $6,000 and $10,000 per case, don't you?
That's what the rate generally ending up as.
So doing the math with those numbers, that means you've made somewhere between $600,000 and over $1 million as a defense expert, in addition to your salary as a professor, correct?
I guess so. Yeah, if you do the math out, I don't know what it would turn
Now
out.
I'd like to talk to you about your experience with the police department in Aurora. Like you said on your direct, you left that department after only 9 months, didn't you?
Yes, I did. I realized that the police force wasn't something I could be a part of.
And you left because of an incident which resulted in someone suing you, which resulted in a lawsuit that the city had to settle, correct?
Yes, the person sued both the police department and myself personally.
And you never forgave yourself for your actions on that day, did you?
No, I don't think I'll ever be able to forgive myself. It's my biggest regret.
And you became disillusioned with police work, didn't you?
Yes, I realized that the police force there were multiple tactics and use of force that I just couldn't stand by, and it was something that I could no longer allow myself to be a part of.
Professor Van Owen, you became disillusioned with the police, didn't you?
Yes.
Now I'd like to talk about the work you did and did not do in this case. You claimed on your direct that you did a crime scene reconstruction, but you never actually visited the crime scene, did you?
No, by the time I had been contacted by the defense, the crime scene would have been a much different crime scene.
And you conducted a partial investigation, isn't that right?
Yes.
And for that partial investigation, you failed to get cell tower records for March 5th, 2020 to see whether Becker and Perkins were where they said they were, didn't you?
That was not my responsibility. Pulling those records, in hindsight, I could have gotten them, but it was not my responsibility to.
Like you said, you admit that you could have gotten those records, don't you?
Yes, but so could have Detective Markowitz, and he failed to, and he has the burden of proof.
You also failed to get the account records for Mr. Brackman's Ring device, didn't you?
That is not my responsibility. My responsibility is to look into the police's investigation.
Professor Van Owen, Professor, I didn't ask you about what you were specifically hired to do in this case. I asked you whether or not you did some of the things you criticized the police for also not doing. You did not obtain the account records for Mr. Brackman's Ring device, did you?
No, as I said before, it was not my responsibility to.
Next, let's talk about your criticisms of police work. First, the scuff marks. You've stated that marks like that could be left uncleaned for up to 5 years. Isn't that right?
Yes, there's no way of knowing how old scuff marks are on the floor.
And about those marks, you stated that they are the only apparent evidence of a struggle?
From what I can see, yes.
You never mentioned the broken plate in your report, do you?
No, I don't.
But you are aware that there was a broken plate in the home?
Yes, I reviewed all of the case materials for this case.
And you are also aware that there's an overturned chair in the home since you reviewed all of the case materials?
Yes.
But you didn't mention that in your report either, did you?
No, because I don't believe that that is necessarily an indication of a struggle.
Do you believe that the broken plate could have also remained on the floor for up to 5 years?
No, I don't think that Mr. Brackman would have left broken glass on his kitchen floor for 5 years.
How about the chair?
I believe that if Mr. Brackman had been stabbed in his back, he might not have been able to stand up out of the chair without it. He could have knocked it over then when he was standing up.
Is that a no, Professor?
I don't think that a upturned chair is a permanent fixture in Mr. Brackman's home, if that's what you're asking me, counsel.
You've seen the videos of the intruder in this case, correct?
Yes, I have.
And it is your testimony that somewhere in those sweatpants and hoodie, the intruder was carrying a very sharp 12-inch chef's knife.
Yes, his clothes are very baggy, and I don't think that a person would be walking around a neighborhood with a knife in their hands.
And it is also your testimony that the intruder who carried the knife intending to kill Mr. Brackman left the murder weapon right there in the crime scene.
Yes, it is.
But you do admit that Mr. Brackman had a complete set of knives in a block with the exception of one slot that was large enough for a chef's knife.
Yes, but those knives are all entirely different brand and entirely different style. I don't think that it came from that knife block.
You also admit, however, that there's an open knife drawer wide open in the home?
Yes, there is.
And you admit that Avery Becker's cell phone was somewhere near Mr. Brackman's house during the time of the murder, don't you?
I already testified to this earlier. CDR data isn't a GPS. You can't tell.
Professor Van Owen, Professor, I'm using your words. I can point you to your witness statement if you would like, but you believe that Avery Becker's phone was near the Brackman house during the time of the murder, don't you?
Yes, somewhere near that house.
You also admit that the size and build of the intruder is the same size and build as Avery Becker.
Yes, but that's not saying much because that height and build is pretty general and a lot of people look like that.
Professor Van Owen, you have previously stated that it is Investigation 101 not to assume things, haven't you?
Yes, I do mention that. I do say that.
But don't you state it's likely Mr. Becker's phone was deactivated?
Yes.
And you also state that the intruder carried the knife into the home despite having no evidence to support this.
I believe that assumption is a much more well-founded assumption.
But you don't have any evidence of that assumption, do you?
I don't have any physical evidence. That's what you're asking.
And finally, about this person, Blair Rollins, you believe that they have a stronger motive to murder Mr. Brackman, but you have no evidence that Blair Rollins even harbored resentment towards Mr. Brackman, do you?
I believe that Blair Rollins' father being sentenced to life in prison is a stronger motive, at least one worth looking into by the police department.
Professor Van Owen, are you saying you're assuming that the motive is the conviction of their father?
I'm saying that it's a reason to look into Blair Rollins.
No further questions, Your Honor.
Ms. Kenny, any redirect?
No redirect, Your Honor.
All right. Any further witnesses from the defense?
No, Your Honor. The defense rests.
All right. Prosecution, you may present your closing arguments.
Your Honor, before I begin, I would like to reserve any remaining time I have for my rebuttal.
Yes, you may do that.
Motive to commit mischief, which resulted in a murder. The defendant had a motive for getting into Mr. Brackman's house and vandalizing it. Once inside the house committing this crime, which the law calls criminal mischief, he was surprised. And although he didn't intend to harm Mr. Brackman, a struggle ensued, and Mr. Brackman ended up with a knife in his back. His death is murder under the law. Good afternoon, members of the jury. My name is Rachel Kidder, and I, for the next few minutes, will show you how the people have established beyond a reasonable doubt that Avery Becker committed second-degree burglary and first-degree murder. First, the elements of second-degree burglary. Under jury instruction number 8, we must prove that the defendant knowingly broke an entrance into or entered unlawfully in a dwelling with the intent to commit the crime of criminal mischief against another person or property. Criminal mischief means damaging the real or personal property of another person. Let's look at the evidence for burglary. The defendant had already vandalized Mr. Brackman's car and was planning something worse for the house. He outlined his intent to do so in the text you saw in Exhibit 14. You also heard the defendant told his mother, "I will get back at Brackman if it is the last thing I do." The defendant's call detail records put him at the scene of the crime during the murder, and the ring security footage shows someone the same height and size as the defendant entering and exiting the home. The people have proven second-degree burglary. Next, the elements of first-degree murder. According to jury instruction number 7, we must prove that the defendant committed or attempted to commit second-degree burglary. And in the course of that crime, or in immediate flight therefrom, someone was killed. Here, we have proven that the defendant's presence in the home was a second-degree burglary. The evidence showed that the defendant was surprised by Mr. Brackman, may have even attempted to flee, but a struggle ensued, and Mr. Brackman was killed. That, members of the jury, is textbook first-degree murder. When you review the jury instructions, you will see that motive is not an element of either crime, but it is an important factor in determining who did this crime. And we have shown you the substantial motive the defendant had by using his own words. You heard from Alex Cifuentes, Taylor Perkins, and even the defendant himself that he was criticized by Mr. Brackman, causing him to vandalize the car. Then when kicked off the team completely, he planned to vandalize the house as well. Today, the defense tried to tell you that the screenshots and cell tower data weren't enough to prove the defendant was there. It's circumstantial evidence. We acknowledge that. However, under jury instruction number 3, the law treats both direct and circumstantial evidence the same. The defense also tried to tell you that the defendant lost his phone and didn't notice it was missing. Members of the jury, I would like you to think of all the teenagers you know that let their phone out of their sight for more than an hour. That list is non-existent, right? And finally, the defense brought to you an alibi witness, Taylor Perkins. Both the defendant and Ms. Perkins claimed they were together all day on March 6th. According to jury instruction number 4, you may believe all of the testimony of a witness, part of it or none of it. You heard Perkins admit that she stepped down from the mock trial team to give Avery Becker what he wanted. You also heard Perkins admit that she met with Avery Becker after she found out she would be a witness at trial today. Taylor Perkins is covering for her best friend, and you need to disbelieve her testimony. As for the defendant, you heard that he lied to his own mother, and anyone who can do that can certainly give false testimony to this jury as well. You need to disbelieve his testimony. There is no evidence for this alibi. The evidence that was admitted in this case shows us that the defendant's motive to commit mischief resulted in a murder. Members of the jury, it is not the people's burden to prove to you that the defendant is a bad person. Of course, it's human nature to want to convict only bad people, but that is not an element of the crimes here. It is your duty as jurors to review the jury instructions and apply them as the court gives you. The evidence does not show that Mr. Becker intended to kill Mr. Brackman, but he did intend to commit criminal mischief and a death occurred. Members of the jury, at the end of your deliberations, we ask that you find the defendant guilty. Thank you.
All right, defense, Ms. Kinney, your closing argument?
Yes, Your Honor. May I proceed?
You may.
Rushed, reckless, guilty until proven innocent. Members of the jury, in their frantic stampede to condemn a suspect, Detective Markowitz's investigation became rushed, reckless, and filled with mistakes. The police decided Avery Becker was guilty until proven innocent, and not the other way around. They only ever had one true suspect, only ever used one interview, relied on faulty cell site data and faulty text messages, and yet were determined to convict a high school boy. Today, we've shown you that the prosecution's case is little more than holes, mistakes, and assumptions strung together by pieces of broken narrative. Now, members of the jury, the prosecution has the burden of proof today. Pursuant to jury instructions 8 and 9, they must prove to you that on March 6th of 2020, Avery Becker committed second-degree burglary by knowingly and unlawfully entering the residence at 444 South Flower Street with the intent to commit criminal mischief. And pursuant to jury instruction number 7, they must prove to you that in course of or in furtherance of a second-degree burglary committed by the defendant, Mackenzie Brackman was killed. And jury instruction number 2 tells you that reasonable doubt means doubt based upon reason and common sense that arises from a fair and rational evaluation of all of the evidence or lack of evidence in a case. And jury instruction number 2 also tells you that if you find that any of the elements of either of these crimes have not been proven beyond a reasonable doubt, you cannot find the defendant guilty of that crime. So, all the elements the prosecution must prove today are contingent upon one thing, that Avery Becker was in fact at 444 South Flower Street on March 6th of 2020. They showed you cell site data to attempt to prove this fact, and all they really proved was that the police team was rushing and desperate to jump to conclusions. You heard from Professor Van Owen that cell site location cannot definitively show the location of a phone. And more importantly, you heard from both Avery and Taylor that Avery was not in possession of his phone on March 6th. He was looking for it as he had lost it the night before. Members of the jury, anyone could have had Avery's lost phone. Anyone could have used it. And yet the prosecution wants you to believe beyond any reasonable doubt that Avery and his phone were at the scene of the crime. But why stop there? The prosecution tried to prove to you that Avery Becker had motive to break into Mr. Brackman's house. They showed you text messages supposedly sent from Avery Becker to Alex Cifuentes. But members of the jury, Professor Van Owen made you aware that these text messages were only screenshots. and that Detective Markowitz never attempted to verify them, despite having the technology available to do so. And on the list goes. Detective Markowitz only ever interviewed Alex Cifuentes. Detective Markowitz never pulled any cell site data other than that of Avery Becker. Detective Markowitz never visited the places that Avery and Taylor testified to visiting on March 6th. Detective Markowitz never truly looked into other suspects. Detective Markowitz never looked into Blair Rawlins. But even putting that aside, members of the jury, the prosecution tried once more to prove Avery Becker's guilt. They brought forth crime scene reconstruction investigator Kyle Kuzak. But Ms. Kuzak's reconstruction sports as many mistakes as as many assumptions as the detective's investigation does mistakes. Ms. Kuzak assumed the scuff marks were indications of a fight. She assumed the knife came from inside the house. And you heard her say that there was only one intruder, despite the fact that in 2 different ring videos, the intruder was seen wearing 2 different pairs of shoes. Members of the jury, assumptions, theories, and guesswork are simply not a basis for conviction. So I ask you instead to think about Avery and Taylor's testimony. Unlike with the prosecution's story, you won't have to stretch your mind or fill in gaps to believe them. Avery just wants to move on with his life, and yet his whole world is being put on trial by a prosecution that clearly wants a conviction, regardless of the faulty and lacking evidence. Members of the jury, don't let the prosecution make Avery Becker guilty until proven innocent. Look at the evidence for yourself and see the reasonable doubt seeping through the holes in their story. Find Avery Becker not guilty. Thank you.
All right, Ms. Kidder, I think you have maybe somewhere in the realm of 45 seconds for your rebuttal.
Rushed, reckless, innocent until proven guilty. That was the defense's theme today. Rushed. Professor Van Owen only completed a partial investigation and accused the police of things that she didn't do herself. Reckless. It is our position that Avery Becker recklessly entered the home intending to vandalize it. And innocent until proven guilty. That's exactly right, members of the jury, and we have proven Avery Becker guilty. The defense is grasping at straws. Their entire case relies on the testimony of Taylor Perkins, who we have proven cannot tell the truth, and this phantom Blair Rawlins, who we cannot even prove had anything to do with this crime. That is why we ask that you find the defendant guilty of second-degree burglary and first-degree murder. Thank you.
Time.
All right, thank you very much. Congratulations, everyone. While we give our scoring panelists some time to finish up their score sheets and submit some things, let me, like I said, congratulations. I apologize for my technical difficulties, but you guys powered through that just fine. Let me just generally say I am so impressed. Let me start by introducing myself. Like I said, my name is Alicia Forbes, and I currently work as an assistant United States attorney for the Department of Justice. And so I've been a federal prosecutor for almost 10 years now. And back when I was in law school, I actually coached high school mock trial. And I also competed in a lot of mock trial competitions while I was in law school. I love doing mock trial. And I also know how much work it takes. And so I just want to commend you all. You all clearly deserve to be here. You've all clearly put in so much work. And I just wanted to congratulate you and thank you for putting in the commitment to do this, especially this year, and to do it this way. I know how hard the struggle is because of, I've had to do real testimony during trial over Zoom, and it's not easy. And so thank you for your commitment, even especially to do it this year, and for all the hard work that you put in. Everyone did a really great job. And I just, again, I'm just so impressed at everyone and their professionalism, at their preparedness, and their ability to navigate this forum, so well, despite the technical challenges that it can present. And I'm sorry, but since I have to switch to my phone, I can't see everybody. So courtroom monitor, do we have any scoring panelists who have popped back up?
Yes.
If our scoring panelists could turn their video back on once they're have submitted.
We've got all the
Is there anyone who's
sheets
ready?
in. We've got all the score sheets in. So Matthew, you want to start?
Okay, great. So yeah, would our whoever would like to go first, or I guess Ms. Peterson, would you like to go first?
Sure, I'd be happy to. I wanted to, like Alicia, commend all of you. The knowledge that you've exhibited about the case file, your competence, just your general familiarity with rules of evidence is really astounding. I'm a staff attorney for the presiding disciplinary judge who handles all the attorney discipline cases in the state. And sometimes that can be a very disheartening position. So you have all sort of made me feel happy and very confident about the future of the legal profession. So thank you very much for everything you've done. And I just wanted to give a quick shout out, special kudos to the last trio of people, the professor and the two counsel. I think that was just textbook cross-examination as well as direct. And I think the professor as well did just a really magnificent job in presenting her her case. So thank you for the three of you, but for all of you, you've done a fantastic job.
All right, Ms. Collar.
Yes. So my name is Carrie Kohler. I've been practicing, I think I'm probably the oldest out of the scoring panelists. But I practiced education law for about 16 years. And then for the past 4 or 5 years, I'm a court-appointed counsel representing parents in dependency and neglect cases. So in child welfare law. So we are in the courtroom pretty much every day. So I'm always impressed. I judged at the regional level as well as state, and I just want to echo them and just how impressive it is. Again, I'm in the courtroom in front of judges almost every day, and I still get nervous and fumble over my words and forget what evidence rule is, or someone objects and I have absolutely no idea what my response is. And that's after many, many years of practicing. So just the amount of maturity and poise that I see is extremely impressive. And then I would just kind of echo just very briefly, kind of the same things that Corey said. The last three were especially impressive. And I think this may be the same two that were on the last, but for Claire Kenny on one team, because I think there might be similar names, Claire Kenny, and then Rachel on the other one. I was impressed both of you at different times on cross-examination did a really good job of being extremely tough and being extremely firm, but still seeming professional and nice, for choice of better words. I think sometimes we get sucked into coming across as kind of being a little aggressive or badgering the witness, and you both did a great job on cross of really getting your point across and impeaching them and being extremely firm, but just still maintaining that professionalism. So I thought that was impressive. And pretty much for all the witnesses, just how well you knew the facts of your case and really didn't get stumbled up on cross, I thought was extremely impressive. So congratulations to all of you. I know you have more rounds coming up, so good luck to all of you.
Hey, Mr. Chaput, sorry.
Yeah. So my name is Matt Chaput. I am a criminal defense attorney. Been doing criminal law for 10 years, first as a DA, and then now as a defense attorney for the last few years. So much like Carrie said, been in the courtroom pretty much every day of my career for the last decade or so. And just like everybody else has said, I want to commend both teams. Everybody had excellent presence, excellent presentation, and just a great handle on all the facts. I think everybody, handled both the making and responding to objections. When you responded, it seemed like everybody had thought out the way their questions were going to go and anticipated at least a large part of the objections they received. and had good responses, and were ready to bring those up. So I thought that was particularly, impressive. I've seen attorneys practicing for years that don't use the numbers when they respond and stumble over their responses. So I thought that was a really great job. I think, both the closings were excellent. I thought, each side presented their case. You all had good themes that you presented early in the openings, and then used your opportunity to question to bolster those themes from the beginning to the end. So I thought both sides did a really nice job of that, and both had used the trilogy to make those themes catchy. And so I thought that again was excellent. So all around a great job by everyone.
Yeah, and I just want to make I know you got another round to get to, but I just wanted to make a couple of comments. First, I thought that both openings and both closings were really excellent. Ms. Wind, I thought you did a really good job tying in your story to but also addressing what the crimes were being charged and kind of briefly introducing those elements. Mr. Ebel, I really liked how you focused on the defense story, and that you focused on telling your story first and focusing on what defense witnesses were going to say, as opposed to sort of automatically backpedaling in opening and letting your co-counsel in closing be the one to sort of pick apart the prosecution case, which I thought, Ms. Kenny, that you did a great job at. And also, Ms. Kidder, your closing was great. You did a really good job addressing and going through the elements, as well as addressing, defense on rebuttal. And, a couple of things I also wanted to point out. I thought, Mr. Holtzinger, you, of all I've done, I think this is my 6th round doing for regionals and for state, but your foundation for those text messages, that's the best that I've seen. I thought you did a really good job laying that foundation and responding to your objections. So I thought that was really well done, but and all the witnesses were really great. I echo that the Miss Trembath, your professor Van Owen was great. Also, our Detective Markowitz, Miss Mail, I thought you did a really great job as well. But again, just congratulations, everybody, and everyone did a really great job. And good luck in your next round.
You guys, I just want to thank you. You're all awesome. And I want to thank our volunteers, because we really totally couldn't do this without you guys. So we really appreciate it. And good luck.
And I think I speak on behalf of my entire team when I say thank you to all of you as well for taking the time to do this for us and giving us feedback at the end.
This was lovely. Thank you so much.
You guys are good to go.
All right.
Thank you.
Bye.
Thank you.
Good luck.
Thank you.